And are you able to share with us what, if anything, came as a result of what was shared with you by CSIS? I appreciate that you determined that you couldn't or shouldn't take specific action with respect to what was shared with you by CSIS. Do you know if that was followed up by someone else or some other body?
I cannot share that with you.
Okay. Now, you expressed a sentiment towards the end of your testimony, and that's, I believe, reflected in paragraphs 4 and 5, that as far as your mandate is concerned, i.e. that which you're directly charged with administering and overseeing under the Elections Act, you believe that both with respect to the 43rd and the 44th election, you were not informed of significant or any instances of foreign interference?
That's correct.
Okay, and that as a result of that, from that perspective at least, and perhaps from a broader perspective, your view is that both of those elections had high integrity, again, with respect to your core mandate?
With respect to my mandate, correct. Based on the facts that I know today, that is correct.
Okay. And I appreciate that you may not be, well, I don't know if you'll be able to share this. Are you, so I'll ask the question, are you aware, and I'm drawing here on how specific those conclusions are you aware of information that could call into question the integrity of the 43rd and the 44th election, information that doesn't engage your mandate, that could call into question the integrity of those elections? So
I think everyone here is aware of the information that is made public, that is serious, that relates to what I described as the broader conception of electoral integrity, and that I believe is important for the Commission to examine and make determinations on. But as I said, I am not in position to make any kind of determination or pronounce on these.
But I guess what I want to know is, and I appreciate that the Commissioner will ultimately have to deal with this, is there other information that you have that might be able to be shared in a non-public setting that could?
There is not.
Okay. Those are my questions. Thank you.
Thank you. So next one is the Human Rights Coalition.
Good afternoon, Commissioner. Good afternoon, Mr. Perot. My name is Hannah Taylor. I'm counsel for the Human Rights Coalition. Mr. Perot, I'm correct in understanding that Elections Canada sometimes receives complaints about alleged violations of the Canada Elections Act, and when you do, you pass that along to the Commissioner.
That's correct.
Are there mechanisms in place to keep the identity of those who submit complaints confidential during the time in which the complaint is in your office?
This is treated as personal information, except with respect to the referral to the Commissioner. I can't speak to the manner in which the documents are preserved in my office.
You would agree that the intimidation of members of diaspora communities in the context of Canadian elections is an issue that Elections Canada is concerned with?
It is.
And from what I understand, Elections Canada is or has been attempting to respond to this type of concern by developing targeted messaging products about the secrecy of the ballot and other safeguards in the voting process.
That's work that's undergoing right now in preparation for the next election, correct?
Okay. They're still being developed.
Yes. Well, there's information on our website right now that is fully developed, and we're working on content for outreach initiatives for the next election.
And this came up briefly with counsel for Mr. O'Toole. In June 2022, you provided recommendations for additional tools for combating foreign interference in Canadian elections to the Speaker of the House of Commons. including the expansion of the rules on undue influence by foreigners to the pre-writ period, correct?
Yes, and in committee, in parliamentary committee, I indicated that, in fact, it should probably be expanded at all times.
And I understand correctly that this recommendation has not yet been implemented. It's perhaps in the process of being expanded. I don't know if you can speak to that, but it's not yet implemented.
There is a bill before the House that was introduced, Bill C-65, that includes a number of recommendations in it that I've made, or that is aligned with a number of recommendations that I've made.
Okay, thank you. I would like to turn to electoral integrity, the principles of which I understand to inform Elections Canada's mandate. You've mentioned that a broader conception of electoral integrity could refer to maintaining the conditions needed for the holding of free and fair elections, and that this is a more useful framework for the implementation of Elections Canada's mandate as opposed to a narrower conception of electoral integrity.
It's true, but it's not quite what I said. I said it's more useful for the Commission to take that broader mandate. When we have what we call an integrity framework that outlines 6 principles that are reflected to a certain degree in the provisions of the Act, and we use that when we devise programs or initiatives, and we challenge ourselves to examine through the lens of these principles whether what we do improves or elements of what we do raises concerns regarding one or the other of these principles. So it's a lens through which we evaluate our initiatives.
Okay. You would agree that a broader framework for understanding the integrity of a broader framework is also more useful for understanding the integrity of a specific election?
Yes, I think so.
Okay. And you would agree that maintaining the conditions needed for the holding of free and fair elections includes ensuring that acts of transnational repression do not impede the involvement of voters from diaspora communities in those elections?
Yes.
Turning now a bit to discussions, a bit of your mandate. When you or Elections Canada considers the issue of foreign interference in Canadian elections and you make assertions as to how free and fair a Canadian election is, you do so within the bounds of Elections Canada's mandate and operations, correct?
That's correct.
It's not the role of Elections Canada to identify or investigate threats of foreign interference in Canadian elections, correct?
We don't do any investigations, in fact. It's the Commissioner of Canada Elections who does investigations.
And Elections Canada engages in analysis of the information environment surrounding elections with its security partners at a high level. Would that be a proper kind of summary of how that works?
So, we receive briefings from our security partners at a high level regarding the nature of the threat environment. I may have misheard your question because I was confusing it with the social media monitoring that we do, which we do separately from our partners, but we share with our partners.
Right, yes. I'd be discussing information outside of the social media monitoring.
Okay.
You would agree that it's not the role of Elections Canada to evaluate and assess Canadian elections?
No, our role is to provide all of the information possible regarding our administration to allow other bodies, including courts, including this commission, including parliamentarians, including ordinary Canadians, to form a judgment. So if you go on our website, you will see there are a segment of our website that shows all the studies and surveys and the reports that I do in order to provide transparency onto with respect to the administration of the election. And that is integral to the idea of electoral integrity or free and fair elections, that this process be observable, that people can pass judgment on it.
Okay. Other bodies passing judgment on it as opposed
Other bodies, that is correct.
So moving now, turning back to the social media monitoring that Elections Canada does. We've heard this morning that Elections Canada monitors public social media and digital content for information focusing on matters relating to the voting process, but not information that could be seen to be partisan. Is that correct?
So the purpose, as you describe, the purpose is as you described it. As we do that, we do come across content that is partisan, but we don't collect it for that purpose, and we do not action in any way that information.
We also heard that Elections Canada focuses on information that can be found in public channels as opposed to private groups on social media or private messaging apps, and private messaging apps. Is that correct?
Correct. We are not, again, we're not an intelligence or investigative body, and I don't think it would be appropriate for Elections Canada to go beyond what is in the public domain.
And Elections Canada does not have the tools to determine the source of the information it gathers on social media, including whether that source is foreign or domestic.
That's correct. Our goal is to protect the information ecosystem, if I can use that term, against misinformation or incorrect information about the electoral process, whatever the source, whatever the intent.
And Elections Canada monitors this specific set of publicly available content during the writ period, meaning the time between the dissolution of Parliament and the election, which lasts about 50 days at maximum. Is that correct?
No, that's not correct. We
Okay.
monitor it all the time.
All the time? Okay.
Yes. The size of the team varies.
Okay.
So during the election period, we have about 25. In the last election, we had about 25 staff devoted to this. It is a reduced staff now. We do weekly reports, for example, so there's less work involved in the writing, but we monitor on a permanent basis.
Okay. And so outside of those maximum 50 days, there's 25 staff members dedicated to monitoring this publicly available information. And then the team grows during election period. That would be the difference?
Yes, last election it grew to 25, I would say.
Okay.
And now it's a bit short, it's a bit less than that.
Okay, during the rest of
I
the...
apologize for interrupting. We do have a request to please slow down with the questioning.
Thank you, sorry. Okay, so thank you for correcting me, Mr. Perot. So during election period, you have 25 staff members monitoring.
I think there's 3 or 5 who are writing the reports and 20 monitoring, but it's a ballpark figure. Yeah.
Okay, and then how many are doing that work during the rest of the year?
I would have to come back to that. I think the size of overall is around 15 now, but I'd have to be more precise if you want to. I could come back to the commission with that information.
Sure.
Those are all of our questions. Thank you.
Thank you. Next one is RCDA.
Bonjour, M. Perrault.
Bonjour.
Commissaire.
Good day, Mr. Perrault.
Guillaume Sirois, avocat pour l'Alliance démocratique des Canadiens russes. J'aimerais qu'on se...
I represent the Canadian Democratic Association of Russians. Can we put up a document, please? ID 13,
À la page 12, s'il vous plaît.
page
Il
12.
s'agit du résumé d'entrevue de José Villeneuve.
It's the summary of an interview with José Villeneuve, the Associate Director General of your organization.
À la page 12.
Page 12, please.
Vous pouvez descendre.
Can we go down, please?
En fait, c'est le paragraphe 48.
Paragraph 48 on page 12.
On peut monter un peu.
A little bit higher up, please.
Parfait, merci.
Thank you.
Donc, depuis ce matin, on parle beaucoup de...
This morning, we've been talking about the overall approach to Elections Canada, but I would like us to have a closer look at a precise case in order to understand how it works concretely on the ground when Election Canada receives a complaint of foreign interference in an election.
Donc, au paragraphe 48, on parle
In the
de-
paragraph here,
d'une plainte en
we
provenance
see
de
that they received a complaint about a person
qui provenait présumément
that
de la
came
Fédération de Russie,
from the
qui
Federation of
était
Russia because
URL.ru.
it had the .ru domain, which is a domain in the Russian Federation. The matter was also then sent to the commissioner's office because it was publicity, and there was a lot of social effect. Yes, there could be a cost for that because it was publicity. It's not evident, but one can surmise that it is the case. So there's necessarily a cost related to publicity. Well, that's the definition of publicity. But when you see an image where it's not always evident to know whether there was actually a cost related to having it there. But in this case, it was publicity. Therefore, it seemed probable that it was. But this has to be determined by an inquiry. Question.
Et c'est pour
And that is why you referred it and you thought it could be an issue of foreign interference and that it should be subject to an inquiry by the commissioner. Questions? So it was information about the leader of a federal party during election and then for disinformation campaigns in this regard without any appearance of it being publicity or payment being made. Would that also deserve to be referred to the commissioner's office, or there has to be a payment? Answer, there has to be something that is against the law. So there could be intimidation, that could be a violation, but in terms of the content that criticizes a leader or a party or that supports and it's in the media or the social media, without anything more than that, that is not a violation of the law, and therefore there would be no cause to refer it to the commissioner's office. I just want to make sure they understand. So in addition to there appearing to be an opinion, is there any other indicators that would suggest that it should be referred to the Commissioner's office? Answer, you have to understand that the exercise that goes on when we receive a complaint from the public about a specific case, an allegation of a violation of the law, implicitly or explicitly, we mentioned that earlier, is an exercise that is rather light. As soon as we think that there might be something that the commissioner should look at, we refer it to her. If the person says, I am complaining, I want there to be an inquiry, we send it automatically, even though a priori it doesn't look like there is actually a problem. But if someone says that they really want to have an inquiry undertaken, well, then we send it on to the person responsible for that, the commissioner. But if it's not clear, but there's an allegation of some facts that could be considered a violation of the law and that could therefore be referred to the commissioner, we do so. Question, is it possible that false information could have circulated on the social media, that there, whether an ad or not, just a false information campaign that was on the social media? Is it possible that that kind of information is there without it being of interest to Elections Canada? Answer, of course. Question, the complaint that we're talking about here in the summary of the interview with Madame Deschamps, was it sent to other people or other organizations rather than outside of Elections Canada? Answer, not to my knowledge. Question, is it typical every time there's a complaint that justifies perhaps the intervention of the commissioner it's sent to her but not to any other organization that you are collaborating with? Answer, indeed, the commissioner has herself agreements with the intelligence community, and she can decide, having a look at that there might be information that is useful to them, but it's up to her to make that determination. Question. Finally, you confirmed somewhat earlier this morning that there's no organization that is independent, as you are, and that concentrates on fighting against that kind of disinformation. So the complaint that we're referring to here, which was a disinformation campaign about a leader of a federal party during an election, doesn't correspond to the mandate of anybody responsible for inquiring and acting. Answer, it's an interesting question of public policy. We live in an open society, and I do believe that we have to have tools that we should be vigilant, and that citizens' education plays an important role. There are university organizations, for example, McGill. We're doing some media surveillance, fact-checking as it's called, of what appeared in social media during the election. So there's quite an ecosystem around the political environment that intervenes to counter disinformation, and that the parties and the candidates, of course. The question is, in an open society, should there be an official organization responsible for the surveying and checking the veracity of information during an election campaign? Well, I can tell you that I don't think Election Canada should be playing such a role. That doesn't mean that we should do nothing. we are responsible with making people aware, and it's work that is done along those lines, and we shall continue to do so. But I do not think that we hope that a state organization be the information police on the internet. It's very difficult. We saw in 2016 in the United States to decide whether a certain content that was accused of being Canadian is or isn't. Question. So if there's if we're talking about a publicity with a URL from Russia, .ru, do we hope that the organizations like the one you mentioned, University of McGill, should report this, or is it useful to have an independent federal organization that would be responsible for fighting against disinformation? Answer. There's a group at Global Affairs that has a look at things like that. There's also the famous Panel 5 that I referred to earlier, which receives information. But you shouldn't say that there's no mechanism of monitoring, but before intervening, or that the state or some organization, the state, intervene on content that's online and that could be of the one that you're talking about. This is a very delicate matter. Question for the groups that you mentioned, these are not organizations that are independent, such as Elections Canada is. Answer, no, they aren't. Question, those are my questions, Madam Commissioner. Madam Commissioner, the next person is the Council for Han Dong.
We have no questions.
No question?
Nuna.
So it's your turn?
No questions.
Then it's your turn?
Thank you, Madam Commissioner. We have no redirect.
Well, prior to that, there was Elections Canada.
I apologize to my friends from Elections Canada.
You're too quick.
I have no questions, thank you.
You still have no question?
I have now many follow-up questions. No, thank you, Madam Commissioner.
So, thank you very much, Monsieur Perrault.
Ça fait plaisir.
So we'll take the
My pleasure.
break. We'll come back at 1:05. Yeah, 1:05.
Order, please. Alors, s'il vous plaît. This hearing is in recess until 1:05 p.m. La séance est en pause.
2:05 p.m., I think.
2:05 p.m. That's right.
2:05 p.m.
5 p.m. La séance est en pause jusqu'à 14h05. The commission has been delayed and will now commence at 2:25. La commission a été retardée et commencera maintenant à 14h25. The hearing will begin in 10 minutes. L'audience débutera dans 10 minutes. Order, please. Alors, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Good afternoon. First of all, I want to apologize for the delay. I realize that presiding over a commission is not like presiding over a court of law. We cannot control everything, especially in a context like this one, where there's some confidentiality and security issue. So I'm sorry, but we'll do our best to proceed efficiently this afternoon. Thank you.
And Madam Commissioner, before we begin with the next witness, Commission Counsel wanted to remind the parties that pursuant to Rule 59 of the Rules of Practice and Procedure, participants must seek leave to cross-examine a witness on their interview summary. This was not done this morning, and it is the expectation that participants should seek leave moving forward. Witnesses cannot be cross-examined on their interview summary or statement of anticipated evidence as a prior inconsistent statement.
Thank you. It's a good reminder for everyone.
Madam Commissioner, we call at this time Ms. Caroline Simard, Mr. Yves Côté, and Ms. Mylène Gigou.
Bonjour. Bonjour.
Donc, on va commencer avec vous, Monsieur Côté.
So we'll start with you, Mr. Côté. Please indicate your name. My name is Yves Côté, C-O-T-E.
Avec l'accent aigu, s'il vous plaît.
Pas de problème. Veuillez lever la main droite.
Please raise your right hand.
Jurez-vous de dire la vérité?
Do you swear to tell all the truth, nothing but the truth, and so God help you? I do.
Et pour vous, Madame Simard?
And you, Mrs. Simard? It will be a declaration. Answered, no problem. Please indicate your name for the file. Caroline Simard, S-I-M-A-R-D.
Donc, veuillez lever la main droite.
Please raise your right hand.
Jurez-vous de dire la vérité?
Do you swear to say the truth, all the truth, and nothing but the truth?
Merci beaucoup.
I do. Thank you.
Madame,
And
c'est à votre
Mrs.
tour.
Gigou,
Sur la Bible ou sur...
do you want to swear on the Bible or affirmation? I will do
d'indiquer votre
affirmation.
nom et
Please
votre-
indicate
et
your
votre
name. My name is Mylène Gigou, G-I-G-O-U.
Veuillez lever la main droite.
Please raise your right hand.
Jurez-vous de dire la
Do
vérité?
you swear to say the
Toute la vérité et
truth,
rien que la
nothing
vérité?
but the truth, and all the truth?
Merci
Yes, I
beaucoup.
do. Thank you.
Vous procédez.
Merci.
Please proceed.
Bonjour, bienvenue.
Hello and welcome.
Là, messieurs, dames les témoins,
So,
je vais m'adresser à vous en français.
Ladies and
et en
gentlemen,
anglais.
witnesses, I will be
Je vais
talking
vous
to you in
demander quand
French
même
and
de,
English. I will
parler lentement,
ask you to
puisqu'on
speak
travaille avec des
slowly
interprètes.
because we are working with interpreters
Donc,
today.
si vous pensez que vous parlez
So
trop
if you're
lentement,
thinking
ralentissez
you're
encore un peu.
speaking too slowly, please slow down even more.
Madame la commissaire Simard,
So,
puis
Commissioner
là, je vais
Simard,
m'adresser à vous comme étant
and
Madame
here
Simard pour
I will
pas créer
talk
de
to you
confusion
as
avec
Mrs.
Madame la
Simard to
commissaire.
not create any confusion
Vous confirmez
with
que
our Commissioner for
le
this
bureau de la Commission
hearing.
des
Can you
élections
confirm that the
a préparé
Federal
un
Elections
rapport institutionnel
Bureau
et ça fait
prepared
partie de vos
additional
preuves devant
report
la
and that
commission?
is part of your evidence before the Commission?
Monsieur,
Answer, I do.
pas le greffier, mais court operator,
So, court operator, can we call up CEFER 0001 EN? So that is the document of the institutional report in English. Answer yes. Thank you. I will ask for CEFER several zeros 2FR. And that's the French version. Answer yes. So, Mrs. Simard, you were interviewed by the lawyers of the Commission on March 6th, and a summary of that interview was prepared. Is that correct? Answer, yes. Did you have a chance? I will ask the next document be pulled up, please. So, question, is this summary of the interview? Answer, yes. Did you get the chance of examining this summary to make sure that it reflected the contents of the discussion? Answer, yes, I did. Question, did you have the chance of bringing any correction or modification? Answer, yes. And I understand that you want to do a change today also? Answer, yes, please. If you allow me, we could do the change. It wouldn't be very long, but I think that I know the nature of the change. In a generic way, could you simply state what the change would be? Answer, it would be a typo in paragraph 16. We indicate about 5% for federal elections between the 2021 federal election, and the mistake is that it's 0.5% for the federal elections. So we need 0.5 instead of 5. Thank you. Were there any other corrections? Answer, no. Mr. Côté, hello. Mrs. Gigou, hello. You were interviewed by the lawyers of the Commission on March 18th, and there's a summary of that interview that was prepared. So could the clerk bring up the document? So, Mr. Côté and Mrs. Gigou, did you have the chance of looking at that summary to check if it reflected accurately the contents of the discussion? Answer, yes. Mrs. Gigou, yes. Did you have the chance of bringing any changes or corrections? Answers, yes and yes. Do you wish to bring changes or corrections today? Answer, no. I would. Paragraph 4. The line before last. Among others, for investigating allegations.
An important distinction.
It makes a big difference.
Words are important. Thank you for that. Donc, Madame
So, Mrs. Simard, I will start with you. Since August 2022, you have been Commissioner to the federal elections. Is that correct? Answer, yes. Mr. Côté, you are the previous Commissioner to the federal elections from 2012 up to June 2022. Answer, June 30th, 2022, yes.
Director of Enforcement at the Office of the Commissioner of Canada Elections, correct?
Correct.
And prior to that, you were Director of Investigations from March 2018 to April 2021.
Yes, that is correct, except for a 6-month secondment during that period of time from February 2022 to July 2022.
Okay. Thank you for that, that specification. Madame Simard, je m'adresse à vous.
Mrs. Simard, I turn to you as Commissioner to the federal elections. You're the current person in position. Can you explain your roles and responsibilities? Answer. As you were saying, I'm Commissioner since 2022, and Therefore, I have a role of observation and application of the law. In simple terms, what that means is that we do investigations in link with any allegations of misdoings that are banned under the Canadian Electoral Act. And I would say that following those investigations, I am allowed to file indictment or monetary fines. We'll call those AMPs in English, and there are also possibilities of signing. I'm having the English words coming up, but we can sign undertakings and compliance agreements. So those are the transactions, and there's possibility of issuing informal measures such as warning letters or information letters. Question. And when you say we're monitoring the implementation of the law, which one are you talking about? Answer, it's the Electoral Act of Canada that is limited to the federal elections. Thank you. Mr. Coté, do you have anything to add to this description of the task? Answer, no. Question, Mrs. Simard, we heard earlier this morning the testimony from the head of elections, Mr. Perrault. Could you briefly educate us on the relationship between the BCF, the Federal Elections Commission, and Elections Canada? Answer, I would say that to better understand, I would separate my answer in two parts. The first part is that we are an organization that is mainly based on the complaints that we receive, and we receive referrals from Elections Canada that occupies 80% of our time, of our work. And so I would say it's the first part that's very important. And the second part is linked to our respective roles in terms of the interpretation of the Act. To ensure cohesion in the interpretation of the Act, we will often collaborate. So we will be consulted to formulate any comments or suggestions in specific context connected with potential changes to the law or interpretation bulletins, and we also contribute at that level. And as regards Elections Canada, are you a branch of it or are you a separate entity? Answer, and so the Federal Elections Commissioner is independent. That's a very important principle. We are independent from Elections Canada, but also independent from the government in place, independent from political parties, also independent from partners such as the RCMP with which we collaborate, or any other stakeholder. Question, how do you become a commissioner to federal elections? Answer, well, there's a selection process with a committee comprised of 4 parties, but I would say in a more formal way in the Act, it is planned that it's the Director General of Elections that proceeds with the appointment in consultation with the Prosecution Office of Canada. Thank you. Question, could you tell us, you spoke about monitoring the application of the Electoral Act of Canada. Could you tell us more about your skills as an organization and define what your jurisdiction is? Answer. Well, what's important to retain is that the work we do is limited to the measures outlined in the Electoral Act. So I would say that it's important to remember, and we will get to that a bit later, but there's some distortion between the public's perception of what we can do, of what is planned in what is allowed in the Act, and truly what is the bearing of those measures. So I would start by saying this, and then I can add to that if necessary.
Est-ce que le BCEF joue un rôle dans le contrôle d'application de les règles entourant les investitures des partis politiques?
Alors, c'est bien que vous le souligniez. Donc, il y a évidemment de grandes exceptions. Ça en est certainement une. Donc, quand on parle de campagne d'investiture, c'est principalement, donc ce sont les règles des partis politiques qui s'appliquent et non la loi électorale, sauf pour la partie du financement.
Maintenant, j'aimerais aborder le traitement des... Vous êtes un organisme qui recevez des plaintes, donc j'aimerais parler de votre traitement des plaintes. Pouvez-vous expliquer brièvement?
Complaints. Can you briefly explain the procedure by which you deal with complaints? So how does your office receive complaints? Reply. There are several ways, but mostly, and maybe Ms. Gigot would like to add information, but I would like to say that the best way is through our website. There is a form, and complainants can use the form to communicate their complaints to us. So there is a system by which we sort the files, the ones that are more routine, the other ones that may be more important. So this varies according to the nature of the file, and then they can be directed to the compliance unit directly or to the investigation group. Question. If you receive a complaint and if it comes under the purview of your office, you receive a complaint and the allegations come under your terms of reference. What are the next steps? Answer. The main stage is that we will carry out a review, as I said, and after this review, or as part of this review, what is important to evaluate is whether there is evidence to prove that there have been violations. And if we reach a certain threshold, I don't want to go into technicalities, but then we can shift into an investigation. So in that case, we will send a letter whose behavior is targeted by our investigation. And as part of this investigation, we will have a range of tools to carry out our work. So for warrants or communication orders, conservation orders. So this is very generally speaking, this is what we do. I'm looking at Ms. Gigot. Is there something else that we should add? No, I think that they resumes the situation. This summarizes the situation. Question. So if the complaint doesn't come under the purview of your office, what happens? Answer. So I would like to specify that that some of the complaints that we receive are not part of our mandate. For example, you were asking about leadership contests. There is also the whole issue of freedom of speech. Maybe we can come back to that later. So in such cases, we developed a practice within the organization by which we communicate the outcome of our work, or we close the file. Generally speaking, of course, there can be exceptions, but we inform the complainants, and I think it's a good practice developed by our office. Question. Do you have the power to take the initiative of an investigation? Answer, yes, I can carry out an investigation if the situation warrants it. Question, and if you identify that a complaint may involve a person or foreign money or a foreign person, I think that then this is treated like an unusual case. Answer, I would say non-routine, generally speaking, and of course it depends on the facts. It's on a case-by-case basis, but for such files which are more complex, yes, such files will be led by experienced investigators. Question? So I would like now to address foreign interference in relation to the mandate of the Commission. So can you address the allegations of foreign interference which come under your purview? Answer. So it might be interesting to understand the scope of the Act in terms of foreign interference by saying what is not part of the Canada Elections Act. So the two examples we just discussed, so for example, nomination campaigns except for funding and also freedom of speech. But when you look at this more closely, I would say that there are three provisions which mention a foreign interference. So Section 284.1, which refer to undue foreign interference. So it is explicitly states exceptions to freedom of speech, and if not, there is a prohibition to unduly influence voters. Of course, I don't have the exact wording with me, but there is a definition of what is undue influence. For example, committing expenses or violations of the law. So in terms of undue influence, it is different from influence as such, which is quite normal in an electoral conference. So this is different from foreign influence, which also happens, for example, when we think of diplomacy. So it's important to keep that in mind, that we are talking about undue foreign influence. And the other type of provision, which also refers to a foreign factor, we're talking about foreign funding. So I have clauses that I could communicate to you, and also foreign broadcasting. And in the institutional report, we had planned to have an annex with about 30 provisions which apply to Canadians as well as to non-Canadians. And of course, it's on a case-by-case basis. But as soon as you add the filter of foreign influence, and when there are organized actions, then we could speak of foreign interference. And there are three parts in the provisions. So intimidation, intimidation of voters and not of candidates. So the second category, money, we talked about foreign funding. And thirdly, information. And for this category, we mention disinformation, and there are provisions in law which may apply, but with a much more limited scope than what the public might think. Question. So voters' intimidation. So the Canada Elections Act contains a provision prohibiting the intimidation of voters, but not of candidates. So can you explain this distinction? Answer. So it's 282.2, I think, which provides for that. So it's about voters' intimidation. And so I'm just quoting from memory. We're talking about constraints, about forcing someone, or coercion, or where or pretense would be used, or misleading. Question. So we're prohibiting voters' intimidation, but not for candidates. So can you educate us? So can you intimidate a candidate? Well, answer. Oh, no, that comes under the criminal code. So I hadn't understood your question. So in that case, it would be the criminal code. The criminal code. Okay. Question. Mr. Cote, would you like to add anything to that? The only thing that I would like to put on the table for future reference that Ms. referred to 282.4, and this clause contains exceptions that are significant and that are often not well understood by the media and by the public at large. So it would be important to clarify this. Question. Yes, we could do that. Mr. Registrar, could we show COM several zeros 9? And I didn't note the page for section 280. I think it's page 154, I think. Thank you, Mr. Cote. You're welcome. No, it's not page 154. Oh, in my copy. No, 2.4. We're almost there. So you're referring to paragraph 3? This is what you had in mind? So 282.4, and we can scroll down to paragraph 3. Okay, so if you can give us not a whole lecture, but an explanation on the exceptions. So maybe later, when you will have questions on specific files, we could come back to that. It will give you an example of things which come under the exceptions. So we say that subsection 1, which creates the violation, does not apply if the only thing done by the person or entity to influence the elector to vote or refrain from voting. And then we mentioned 3 things. So an expression of their opinion about the outcome or desired outcome of the election. So you would have a foreigner who says, I want the ex-government to be elected or not. B, a statement by them that encourages the elector to vote or refrain from voting for any candidate or registered party in the election. So a foreigner who would say, you should vote for this candidate, X or Y, and see the transmission of to the public through broadcasting. And then there is a whole range, so electronic or print media, interviews, debates. So this is part of an exception. For example, a British, French, or US magazine which would write an editorial saying that Canada should do such and such a thing during the next election. So this also comes under the exceptions. So this is not caught by subsection 1, which creates violations. If I go back to B, you say that a foreigner might say, you should vote for such and such a candidate in the election, and that's allowed under the law. But in a case where they say, you should vote for such and such a person because otherwise there will be consequences for your family in X country, so would that be captured? Reply, it would be captured under B because the exception talks about by an intervention encouraging the elector to vote for or against someone. Well, we would have to see what the threats are about. For example, if it can take the form of an intimidation or of a constraint. But it would be a different dimension, and it would be very fact-dependent. So we would have to see what happened, what was said, what was done, to see whether the definition of coercion might apply or not. Question. We will come back to that when we look at specific cases. Question. Ms. Simard, I think you addressed a question earlier when you made a change to your summary interview, or to your interview summary. You're talking about the percentage of complaints in terms of foreign interference concerning allegations of foreign interference, and 2021 it was 0.5 of complaints that were received. Answer, yes, out of 4,000 complaints received in 2021, 2022 complaints were identified in relation to foreign interference. So if you do the math, you have 0.5% question. And for 2019, answer, 201 complaints were identified in relation to foreign interference. So it's a percentage of 2% of complaints for 2019. Question. And generally speaking, Ms. Simard, how do you see your mandate in terms of the foreign interference file? So I would say that the mandate is a mandate to observe the law and to implement it. So when there is a connection to foreign interference. Question. Mr. Cote, during our meeting, you mentioned issues with foreign interference. I don't know. And you said that there were unknown unknowns. So you spoke about camouflage of funds. I would reply, I should have said known unknowns and not unknown unknowns. What I was referring to is that there are several things can happen as part of an electoral campaign. So it is very likely that we will never hear of that. For example, if you have a foreign country giving money to a Canadian citizen, an X sum, and who would say to the Canadian citizen, you will transfer these funds to the campaign of candidate B. So in such circumstances, the person who received money from the foreign government has ties to the foreign government, and when that person gives the money to the candidate, the candidate will have no way of suspecting that the money comes from a contaminated or even illegal source. So I think that this kind of situation, I presume, could occur. So I should have referred to known unknowns. So such circumstances are very unlikely to be discovered by people like us. There is very little likeliness that we would have complaints, because it would have to come from the foreign government or by their proxy. So they would have very little interest in raising awareness of such activities. So when these things happen, the likelihood that we will become informed is very minute. Question. So don't you have tools within the office of the Commissioner of Canada Elections to detect such wrongdoing?
Quel genre d'outil pourrait nous permettre de faire ça?
I don't know what type of tool would make it possible for us to do that, because, as you may know, and we'll come back to that, we have investigative powers we talked about that are somewhat limited. We cannot, for example, attempt to intercept telephone communications. So, but fundamentally, the country that acts badly with their accomplices has every interest in keeping that covert. and secret. So it's not necessarily a question of investigative techniques, it's just the way that things would occur. So that they are undiscoverable to all practical purposes. Question. My next question, I won't make a link to what you just said and the subject of the next question, but you've also learned that the OCC is not a designated distributor of information coming from FinTrack. And to obtain information from FinTrack, you have to go through the RCMP. Is that a problem for you in investigating allegations of foreign interference with regard to the elections of 2019 and 2021? A response. As far as I know, and I'll ask Madame Gigoux to add to it if she knows, but that was not identified as the source of a problem or source of an obstacle which would have kept us from doing the work, because the understanding that I have, the memory that I have is that we could go through the RCMP, which can receive information from FinTrack. So in those circumstances, it's not as though the avenue was completely shut off to us. So, Madame Gigoux, if you would like to add to what I've said. I have nothing to add to that answer. Question, and we'll come back to that a little later when we'll raise another case, but I think that has more to do with Madame Simard. Mr. Côté, I would now like to raise the question of the approach of the Commission with regard to foreign interference as the elections of 2019 and 21 were approaching. I understand that foreign interference became a major concern for your office over the previous year, the year preceding the 2019 elections, and you had also in mind the presidential elections in the United States in 2016. Can you talk about how the OCC thought about the possibility of foreign interference and how you went about to preventively attack the problem? Answer. Are you expecting a short answer from me? Because that opens up so many different things. But maybe, and in a general way, as you let it be heard here, having looked at what happened during the American election in 2016 with the interventions of foreign countries, which were entirely negative and malicious, as all reasonable a person might assume. If it happens on the other side of the border, it might very well be happening on our side of the border as well. So, armed with that conclusion, we asked what we may do, and we set in place various measures, and we undertook various initiatives to attempt to prepare the best way we could. Among those initiatives, there was the fact that, and it's especially Madame Gigoux who was responsible for that, and she did that very well, to establish and strengthen links to federal organizations which have a role to play in that type of thing. And I think that at the OSRS, at the Communications Center, CSE, and the Global Affairs, we established and strengthened those links to see how communications could be carried out. And I think that this comes out in the institutional report that Madame Simard submitted. We renewed an agreement with the RCMP and concluded one with the with CSIS. So that was in terms of the actors that I would call federal. Then, in a general and very continuous way, as the Director of Elections had meetings with what we call the Advisory Committee of Political Parties, which is an organization that was created under the Act. We made sure we were present, and we made sure that we were present to remind those people of what our role was. And the question, I didn't mention it every time, but the question of foreign interference was important, and I made them aware of the fact that we were there if they had concerns that they should come to see us. Then, in terms of education, if you will, and the awareness building of our people, we brought in experts in the area, university professors and a former Canadian ambassador and a former CSIS director who sat down with our investigators, our analysts, and our lawyers, and who informed them of what they were able to note and see externally in carrying out their functions. I think that I will stop there unless if Madame Gigou has something to add. But what we wanted to do was really make our staff as informed as possible and as alert as possible to the fact that those things, if they weren't occurring, they very well could occur during the course of the campaign or our federal electoral activities. Madame Gigou.
Just maybe in addition to the MOUs or the Memorandum of Understanding, we also engage with the various departments as well within that were members of SITE or became the members of SITE to communicate our mandate, talk about the parameters of our legislation, in particular as they may relate to foreign interference as well. So that was another component here. And also engaging with Australia in terms of their lessons learned in their country, and as well as provincial organizations that had recently had elections so that we could build on the lessons that they had learned as well.
Why specifically Australia?
I think with regards to their ecosystem as well and relationship with China as well, it was identified as a country with which we should be speaking. And we also had the benefit of having one of their representatives here in Canada for some time. So it was an easy face-to-face engagement with that person as well, and a good way to build the relationship. So maybe that's what I would add to that as well.
And
Maître Ferguson, j'ajouterais seulement ceci aussi.
And I could add, says Mr. Cote, and it's a number of our investigators were former police officers, and we did that in a very continuous way. We were in communication with the Association of Chiefs of Police, which has an annual meeting, so we made sure that they were informed as much as possible, hoping that the information that we were transmitting to the chiefs of police would be moved on to the police officers on the ground, if you will. So that was part of our mandate. What we were doing in the messages was that when we approach you and we inform you that there may have been an infraction to the Elections Act, that there's somebody specialized here in Ottawa, who deals with that sort of thing. Question. Thank you. So you were making your office known to other organizations involved in the application of the law and involved in information and security. Is that correct? Answer, yes. Question.
Digital platforms. So this is something that I think you were involved in with respect to having platforms sign on to the Canada Declaration on Electoral Integrity Online. Can you speak a bit to that? Who were the platforms that you were engaging with ahead of the 2019 and 2021 elections?
Certainly. Just to maybe clarify in terms of the question, however, the declaration, I was not specifically involved in that. No. My role consisted of building a relationship with these platforms to communicate who we were, what we did, and understand the mechanism by which we could request information, whether it be subscriber or if it was content, and also understand the parameters by which they may remove material on a digital platform as well, with the understanding that that would be done in a context of a contravention of the Canada Elections Act. So the idea was making sure they know who we are, what we do, and why we're calling and why it's urgent, in particular if it's happening during a general election period where we want to ensure compliance and swift results. So in the lead up to the 2019 general elections, that was part of my mandate to engage with Facebook, Microsoft, there were others as well, to have that understanding. Again, in the lead up to the 2021 general election, that was also part of my mandate as well, and we expanded on some of these platforms as well in the lead up to that snap election, so an early election.
Okay. In the lead up to either 2021 or 2019, have you had any engagement with platforms such as WeChat?
In preparation for the general elections, I did not, or our office did not engage with WeChat specifically for the purposes that I've described.
And what types does the OCCE, the Office of Commissioner of Canada Elections, engage in online monitoring?
We do not. In fact, we do have an analytics team that conducts passive collection, but they do so in response to a specific complaint or review or investigation that we have, and but that is the extent of their mandate. They do not proactively monitor the environment or anything of the like.
I'd like now to turn to investigations and relationships with partner agencies. Ms. Gigoux, you are the Senior Director of Enforcement and the former Director of Investigations at the OCCE. Can you speak about your investigations unit? How many are you, and what types of tools and powers you have to carry out your work?
Certainly. So when I initially took the job in 2018, we had a team of approximately 12 investigators. Since then, my responsibilities have broadened to not only include investigators, but also paralegals and analysts that conduct the open source research as well. Our directorate as a whole has grown to approximately 28 individuals, including our executive director that leads the group. And as part of that, and could you repeat the second part of your question?
So what types of investigative tools and powers that you enjoy?
Absolutely. Thank you. And I think it's Commissioner Simard that mentioned earlier some of our tools, but essentially we have tools that you could expect to be used in the general course of a review or investigation. For example, collecting information or evidence from witnesses and complainants and the like. But we also have formal tools where with judicial authorization, we can seek evidence, whether it be a production order, preservation order, or a search warrant. All those obviously are require a certain threshold for us to be able to use these tools, and we must request judicial authorization. In recent years, our toolkit has been expanded with the addition of, to the Canada Elections Act, the ability to compel witness testimony under oath and the ability to request a written return. Again, these require judicial authorization, and we need to meet a certain threshold to be able to use these tools.
So you can essentially, when you say that you have the power to compel, you apply to a judge to obtain the power to compel a witness to answer questions that you may direct.
And to be clear, it's to compel a person, but the information cannot be used against this person.
Right. So the protections of the Canada Evidence Act and the Charter.
That's correct.
Okay. What are the challenges, and this is a question I could address to all three of you, but what are the challenges for the OCC in investigating foreign interference-related issues, either allegations or concerns of foreign interference?
I can go first if you prefer. Mm-hmm. I note that our institutional report and the two witness summaries certainly provide an overview of some of these challenges. Mm-hmm. And maybe just to build on that, on perhaps from my perspective, three key points: access to evidence, technology, and the tracing of funds. And to talk a bit more about access to evidence, I think our investigators can be caught in a loop of needing evidence to get evidence. So essentially, we do get complaints, we do receive allegations, but we need something concrete or tangible or a lead to be able to pursue our work. The reality is, in some instances, no witnesses are identified, or some are, but do not wish to cooperate. And as I just expanded, and as I was just referring to the tools, we need to be able to have sufficient grounds to be able to use that tool, including to compel someone to speak to us. So I think that's one of the difficulties, and we know that the harder it is to access evidence or information, the more time passes, the more difficult it gets for us. In terms of technology, identifying who's behind the keyboard is another challenge. And depending on the scenario and how it presents itself. So I think that's one thing. And on a second, a spin-off to that as well, is also digital platforms with closed access, or by design, you need an invitation, or it's restricted pages or groups. That can create some challenges from an investigation perspective as well. And the third one would be the tracing of funds. Obviously, being able to identify the source of the funds and being able to link it back specifically to the allegations is also a challenge, and particularly when we're talking about cash, intermediary, other means of using untraceable mechanism, prepaid cards, or the like. What I think I'm describing here, however, doesn't just apply to allegations of foreign interference in theory. It could also apply to other types of allegations without that foreign component as well. And if I can just maybe close off as well, I would expect that these are not just challenges that are unique to our office, but likely for most law enforcement agencies as well.
OK. Est-ce que vous avez quelque chose à ajouter à cette description-là?
Moi, j'ajouterais peut-être...
Question, do you have anything to add to that description? I could add, Mr. Ferguson, something that it seems obvious, but it's worthwhile putting on the table so that everybody remembers it. There's, in theory, I say in theory, the possible recourse to the MLATs, mutual legal assistance tweaks. So obviously that's a process that exists for those such as you. I think we have used it. We realize that it's very slow and complicated, but also what we need to bear in mind is that it's only with countries with whom we have concluded agreements. So there are many countries, and the countries that were named within this this hearing and elsewhere as well, with which we have no agreement. The possibility for us of forcing someone within one of those countries who doesn't cooperate with Canada, forcing them to provide us with information or some of their expats, that basically doesn't exist. Question. So what you're describing is that even if we have a mandate at an international level with a country, a friendly nation, it's already difficult to receive information. If it's a country with which we don't have a treaty, it's all much more difficult, if not impossible. Answer, I would say it's virtually impossible, yes. Response, yeah, there have been good answers, but if I could add in as well. Yes, go ahead. I would add 4 challenges to this long list. The first is in terms of legislative changes, obviously ensuring that we have all the means, all the tools, that is, that we need under the law. Also, it's important at a legislative level to make sure that we're consulted when there are changes to other laws that have an impact on us. I would say that's the first challenge to identify. The second one is that obviously it is obvious, but a lot of effort has been put in the past to be known to the public and to our partners, but we really need to continue with that effort. You can see already that there are challenges once again in having people come to see us, and that's really a basic thing in cases like this. They need to come forward to submit the complaint and act as a witness as well. The third challenge is one of resources. We were able to do the work up to this point, and there's that expertise for very complex files internally. And despite everything, we anticipate that with the next elections and possibly with a greater volume, have some concerns in terms of resources. We're working presently with a budget of $6.6 million. And what that will make it possible to do is that we have access, even though we have access to certain funds, let's say a certain flexibility to access funds, that doesn't ensure stability in terms of the organization, and that's very basic at this point in the development of the organization. And the fourth thing is in terms of information. There are challenges, obviously, to structure things properly, to have the infrastructure in place to be able to take in, collect, and deal with conservation and everything, and that is being set in place to complete what has been done in the past. Thank you very much.
Question. Essentially, by doing the promotion of your office, you may have more complaints during the next elections. Answer, yes, indeed. Question. So I understand that the OCCE has a memorandum of understanding with the RCMP. So, Mr. Clerk, can you bring up the next document, please? So this is the MOU, document 42. So could you explain what this memorandum of understanding is with the RCMP? What does it do? Mr. Côté, I think you're the one who signed this memorandum. Answer. So it does different things. The main points are maybe the following, that we wanted, and I think this was just renewing something that existed before, but in the context of this MOU, we wanted to confirm the fact that when the RCMP receives information saying that the Electoral Act has been violated, that the information will be transferred to us. But mainly, I think that what we wanted to do here was to confirm certain rules and approaches between our office and the RCMP, so that in circumstances where, for example, they would be asked to work with us on an investigation, it can be a joint investigation, which could happen but rarely happens. An important dimension for us, Mrs. Sima told you that our office is fairly small, and in the field of deep fakes and very intricate technology, we could have the expertise of the RCMP that's already there, so that they could work for us to help our analysts go forward on the investigation. There could be some circumstances where our investigators would like to have some information on a given citizen, and in that moment we'll ask the RCMP so that they go in the CPIC system to go get information. It's very important to... So the CPIC is the police, the Criminal Information Police Center, that's right. And I'd like to underline that the MOU plans for those exchange of information to be done following the applicable laws, including the Act on Privacy Protection. And on this, I would like to open an aside. When Mrs. Gibout talked of our tools, another tool we have since recently is that Mrs. Sima's office has been recognized as being an investigatory body under the Privacy Protection Act, so it becomes much more easy for our office in an investigation to go see other organizations and other federal departments to ask them to transfer the information. So I come back on this. The MOU with the RCMP is very clear when it comes to everybody having to respect the applicable laws. And maybe the other dimension of the MOU comes to mind is that there are financial measures, in the sense that the RCMP is doing work for us. We expect that, of course, there would be an invoice, so that they would be compensated for the resources that they allocate to us. So that's what I retained from the MOU. Is there something else, Mrs. Gigout? Answer, no, I think this frames the relationship with the RCMP well. Question. Mrs. Gigout.
Thesis. Mr. Core Operator, CEF, several zeros, 43 and 44. We'll pull up 44, please. And When was this a memorandum of understanding put in place with with CSIS?
I believe it was put in place in 2019, but I don't have the specific date.
If we could go to the end of the document, I'm going to suggest it was the September 26, 2019. Signature of Mr. Côté. Vous reconnaissez votre signature, Monsieur Côté?
You recognize your signature, Mr. Côté, I hope?
September 26, 2019. Do I understand that prior to this, there was no memorandum of understanding with CSIS?
That's my understanding, yes, if the question is to me, yes.
Sorry, I'll continue with the question to you. The fact that there was no memorandum of understanding prior to this, does that mean there was no engagement or relationship with CSIS prior to this memorandum?
No, that's not correct. In fact, prior to the MOU, there was certainly engagement with CSIS. My first recollection of a meeting with CSIS would have been in June 2018, I believe, from memory. Again, as Commissioner Côté explained, given the environment, the ecosystem, the objective was to build a relationship with CSIS so that our office would be better informed about general threats and issues that could be in this space. And that relationship developed with CSIS, but ultimately a request was made to discuss the possibility of having a formal MOU with the service.
Okay. And can we, if we speak about the purpose of this particular memorandum of understanding, I understand if we go to page 3 of the document, page 3, a bit further down, if we go to the purpose and scope, outlines principles and requirements governing information exchanges between the Commissioner and CSIS, the Commissioner being the Office of Commissioner of Canada Elections, in accordance with the respective mandates and applicable laws. And the document disappeared. Right, okay, and if we go now to page, I believe it's page 4, or this is page 5, sorry. At paragraphs 4.2 and 4.3, information shared by CSIS or the Commissioner may only be used to the extent authorized by law and subject to the participants' respective policies. And pursuant to relevant authorities, the Commissioner may share information lawfully or incidentally collected in the performance of its mandated duties and functions with CSIS, either proactively or in response to a request where relevant to CSIS's mandate. So I understand that CSIS, this protocol, this memorandum of understanding defines an information sharing relationship between the two organizations. Is that correct?
Yes, I think that's correct.
Okay. If we now move to engagement with CSIS ahead of the of GE 43, the 2019 general elections, can you speak to that?
Yes. So there was this, just trying to think in terms of time. So 2018, again, that's the first specific recollection that I have of a meeting with CSIS where we were informed of general information about the ecosystem and the like. Over time, as part, ultimately site was put together. And as part of that initiative, our organization certainly felt that it was important to engage with the members of site, which included CSIS. And as part of those efforts, we convened a meeting to speak about our mandate and key provisions related to the Canada Elections Act, which included CSIS. So that's the first time that I specifically recall in terms of these discussions where we were really talking about our mandate and our role at more of an operational level.
Okay. And now I'm going to, if we now move to engagement with CSIS ahead of the of GE 43, the 2019 general elections, can you speak to that?
Um,
I'm going to Oh, before I call up a document, in relation to complaints or reviews or investigations springing from either 2019 or 2021 elections, has CSIS ever provided, I think the term is actionable intelligence, that has led or assisted the OCC in an investigation?
So throughout the period of 2018 to 2024, the service has provided briefings and an opportunity to review material, all of which was informative about the environment and some of the threats. None of the information that I received was specifically actionable in an investigation, and the information that was shared for intelligence purposes.
Okay. Now, if we just talk about the process of you receiving, when I say you, I mean the OCC, but also you specifically, Ms. Gigoux, the process of receiving intelligence from CSIS, how does that go about? Can you just explain the process a bit?
Yes, certainly. So generally speaking, in accordance to the process that was put in place, and in most instances, if not all, it was at the request of CSIS, a request for a meeting, where it was either a verbal briefing or the opportunity to review an intelligence product and an opportunity to ask questions about that product. In each of these circumstances, there was an agreement that there would be no notes of the document or the content of the conversation, and I did not retrieve any documents from the service in those specific circumstances. There was a process by which I understood that I could request a use letter, or I believe in the prior period, it may have been called a disclosure letter at that point. And if that was requested, then the service would consider it, and if so, provide it to me at a later date.
Okay. And when we talk about disclosure or use letters, we're talking about intelligence or evidence?
We're talking about intelligence. And in fact, the document that we would receive, if it's a use letter, it would specifically identify the purpose for which I could use it, and all of it states that it's for intelligence purpose.
Okay.
And I would just want to clarify that, to the best of my recollection, that's what each of these state, but I have not specifically reviewed in preparation for this testimony, these letters. Yes.
Okay. Thank you for qualifying that, Ms. Gigoux. And can you estimate how many times you were met or briefed by CSIS between 2018 and current day?
I would estimate that either myself or for certain, I estimate 15 to 20 meetings would likely have occurred. Those meetings could also include, in certain circumstances, calls or also discussion on more operational issues as well. For example, I have recollection of like just generally digital platforms, for example. But because I have no notes of those meetings, it's difficult for me to quantify specifically the number of meetings with CSIS.
Okay. I'm now going to call up documents that have a series of documents that have been made available publicly to the Commission today.
Could I just perhaps add something?
Before I call up the document, sure.
I just want to clarify perhaps for the audience that the reason that I did not familiarize myself with the documents in preparation for this testimony is that so that I did not inadvertently share information that was classified.
So that you didn't prepare for this part of the testimony because you didn't want to inadvertently disclose information that you are bound to secrecy.
Exactly. Thank you.
Now, I'll call up a first document, which is CAN ending by 19300. Now, I'm just we could scroll through the document very briefly. First of all, Ms. Gigou, before today, have you seen this document? Before today?
I'm not sure whether I've seen this document before today, this specific one.
Okay, and we see your name. It's a meeting. The subject is the CCE, Strategic Case Management Meeting between CSIS and CCE, sometime in 2019 at CSIS NHQ. The persons from your office that were present were yourself and Mr. Matthews, Al Matthews. And the purpose of the contact was pursuant to the CCC framework. The Strategic Case Management Meeting was convened to discuss PRC-related foreign interference cases during the 2019 Canadian elections. And I understand you cannot, first you have a recollection of a meeting, of this specific meeting, or independent recollection of the meeting, I should say.
Okay. I want to clarify about whether or not I've seen this document before. As part of the this public inquiry, I did recently review certain documents for possible redactions. I don't specifically recall if this is one of the documents. But your question about any meetings, the content of any meetings I attended with CSIS, first of all, these would not be my notes. This is not my documents, and I did not take any notes during the meeting, and as such, and the content of the document itself, I'm unable to discuss it in this forum.
Okay, and just to be clear as well, because and maybe it's not clear, but this is not a document coming this is not a document produced or prepared by the CCE, correct? The OCCE.
This is not a document that was generated by our office.
Okay, thank you. I'll call up a second document, 19301.
I may not have that. Hold on.
Please allow me a moment, Mrs. Commissioner.
I think it's on the screen.
That's 301, yes. The last document was 300, this document is 301. I'm going to scroll through this document as well, Ms. Gigou. This is 19301 on the screen. And before today, same question. Have you seen this document? Is this document generated by the OCCE?
This is not a document that is generated by the OCCE.
Okay. I'm going to suggest that this refers to a same meeting. It's a different document that refers to the same meeting. Do you have any information as to that?
I'm unable to discuss the content of any discussions that
you've had with CSIS in this course of this meeting. Okay.
Thank you.
And the purpose here, and I'm not asking you to comment it, but if we go just to the purpose, Mr. Court Operator, is pursuant to the CC framework, the strategic case management meeting was convened to discuss PRC-related foreign interference cases during the 2019 Canadian federal election. I'm going to call up this next document, CAN 019302. And I'm calling up these documents primarily because they weren't available to the parties and the commission before today. So next document is 302. And if we could scroll through the document, again, date, place, 2019 CSIS NHQ. Persons present are the same, Ms. Gigoux and Mr. Matthews from CSIS, from the CCE. Purpose of the contact pursuant to the CC framework, the strategic case management meeting was convened to discuss PRC-related foreign interference cases during the 2019 election. And if we go a bit further, there was a discussion of a disclosure letter that was sent to the OCC, and I understand, again, your answer is the same. You cannot discuss the content of this meeting, correct?
That's correct.
Okay. If I now call up, I'm going to skip a document and come back to it, but I'll call up the CAN 18372.
Was that 18372?
Is that, yes, 18372, correct.
I don't have that document.
Madam Commissioner, I think we may need 5 minutes to just arrange the next document, if you don't mind.
So we'll take a break.
The proceeding will recess for 5 minutes. L'audience sera en pause pour 5 minutes. Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Merci. So, Ms. Hugo, we were now document 18372, donc CAN 18372 is on the screen. I recommend we read through the document because I understand this is another meeting you attended, but again, you are not at liberty to discuss the content of the meeting beyond this document. Correct?
In reviewing quickly, it appears there are multiple dates. It seems to provide an overview of various
Yeah, I'm sorry,
meetings.
I misframed the question, and
No,
my
that's
colleague
okay.
reminded me that this is an overview of a series of engagements with the OCC and between the OCC and CSIS. So we read through the document at the very first. If we go to the top of the document, engagement with OCCE. The site task force was established in 2018 with a mandate focused narrowly on examining foreign interference in elections. The membership of site is GAC, RCMP, CSIS, CSE, as well as participation from PCO. While CSE was historically the chair for the site task force, this has recently moved over to CSIS. And then if we go down, engagement with OCCE has generally been the provision of briefings by CSIS to OCCE, the provision of analytic products, which OCC can read in CSIS HQ, and discussions within a one vision framework. The following relates to specific engagement with OCCE. So the following relates to specific engagement with OCC, and then it details on 2018, the 1st of October 2018, OCC attended CSIS HQ for a reading session. On the 22nd of June 2018, IAB provided OCC with a classified briefing session regarding threats to Canadian democratic institutions and processes with particular attention on China. The next bullet is CSIS and OCCE signed an MOU on the 26th of September 2019 for the exchange of information for the purposes of the Canada Elections Act, the Referendum Act, and the CSIS Act. The next bullet, the service spoke with OCC during the 2019 federal election regarding allegations of irregularities during the vote in Don Valley North. I continue down the document. The service met with OCC on the 2nd of November 2021 to introduce service operational desks and discuss lessons learned. A review of the site task force was provided. CSIS provided an overview of FI and a briefing of generally what was seen during the 2019 and 2021 elections. The service met, next bullet, the service met with OCC on the 19th of January 2021 to provide the OCC with a briefing on threats in the lead up to a federal election. This briefing was not specific to PRC FI. And on the 25th of February 2021, CSIS met with OCC to provide an unclassified briefing on threats to democratic institutions and FI activities. We go to the next page. On the 16th of November 2022, the site task force comprised of CSE, CSIS, GAC, RCMP with input from PCO, DI, and SI. SNI briefed the new OCC Commissioner, Caroline Simard, and her team on the site mandate and shared key observations from 21 GE 44. Next bullet. I think we could stop there for the next bullets because we're getting outside of the terms of our reference. So if I bring you back to this document and the first page, and just a bit down the page, if we go to, yeah, there we are. So CSIS, I understand there was a meeting between CSIS and OCC on the 26th of September 2019 for the exchange of information for the purposes of the Canada Elections Act. So that was the MOU. And there was another meeting where among other things, I put it to you, I suggest to you that there was another meeting where the service spoke with OCC during the 2019 federal election regarding allegations of irregularities during the vote in Don Valley North. I understand in this particular meeting that I'm referring to, that was a topic of among others. Is that correct?
What I can say is that as per, I referred earlier to the process whereby I did not take notes of any discussions with CSIS, and these are not my notes, and they cover a number of years based on the dates that are that appear there in the document. Any information that I would have received would have been classified as well, and not anything that I can discuss in this setting.
Okay. All right. I will. Si me permettez, Madame la Commissaire.
If you allow me, Madam Commissioner.
If I could also move on from CSIS I would say not for a moment, I'll move on from CSIS to talk about site and RRM. Can you really describe the relationship between OCCE entities, with these entities and site and RRM?
So, okay.
So RRM, the rapid response mechanism, yeah.
No, absolutely.
Okay, yeah.
So in lead up to the 2019 general election, I alluded to a meeting held at our office whereby I convened, I believe, likely DG level counterparts at CSIS, CSC, GAC, RRM, and the RCMP to discuss our office's mandate, key provisions related to foreign interference, and the role we saw ourselves play in this sphere. We're not a member of SITE, but that in the event that there was any information or that they had awareness about our mandates, so that if there was anything to be shared with our office. My recollection of that discussion was that they found it to be informative and thought that a workshop or session, a presentation to some of their staff could be helpful as well. So a couple of weeks later, we did organize a session again at our office where we communicated to staff within those organizations information about our mandate. In that context as well, we communicated a letter and the deck that was shared in those sessions to those organizations.
When you say the deck that was shared, you're
the
presentation, and you're referring to specific provisions of the Canada Elections Act as pertains to foreign interference?
That's right. That's correct. In terms of building on that, for the 2021 general election, this was a federal election that was called early. But what we did do, again, to continue building on these relationships, we invited each of these organizations to come speak to our office so that our staff could hear about their roles, mandates, and the like, so they'd be better informed about respective mandates. And in that forum, we also, if it was someone new within those organizations that I didn't already have a relationship with, had a bit of an exchange in terms of our mandate as well. We recommunicated in the lead up to the 2021 federal general election information about our mandate with key individuals within those organizations, essentially my counterparts.
Okay. Maintenant, j'aimerais aborder.
Question. I would right now like to raise Madame Simard, the fact that you've referred to a number of provisions in the Canada Elections Act. I'm having trouble with that word today. The Canada Elections Act relating to foreign interference, to attack the phenomenon of foreign interference. You've alluded to an additional report, SEF-ER, a number of zeros, FR. The interpreter may not have correctly understood the number of the document. I will refer you to page 27 of this document. I think actually it's page 28 of the PDF. So page 28. This is appendix to your institutional report, which draws up an inventory of clauses regarding foreign interference. You're talking about disinformation and misinformation. If we could scroll down a little bit in the table. There are certain false statements which are forbidden during an electoral period under Article 91. Also in your table, the reference to 282.4. This is exerting undue influence on the foreigners and exerting undue influence. This document is there. We had raised a number of clauses in it or provisions in it. I would like to raise the question of certain specific files. It's a question aimed more at the former Commissioner, Mr. Cote. Can you describe, in fact, I will take you to certain files and discuss with you certain examinations or investigations flowing from the general elections in 2019. I will start with a number of files sent by Elections Canada, and I will ask you to describe for each one of these the decision-making process on the part of OCCE concerning the closing of these files. I will refer to a first file, CEF, a number of zeros, and it ends in 7. I don't know if you undoubtedly don't know that by heart. If I say Time Magazine, does that ring a bell? Yes. It's a file that includes, do you have it? CCEF7 question? Response, yes. Yes, I will speak to you. That's an error. There was an error in that file. We'll make sure that it's fed into the database of the parties. So it's a file that contains a number of complaints relating to an article in Time Magazine, an American publication, during the 2019 elections, and there's a reference to the first Prime Minister when he was a young man in blackface or brownface a number of years earlier. Can you talk to us about that file and the institutional process in closing this file? Yes, I would answer. I would answer, first of all, that you talked about more than 100 complaints or 100 communications regarding that article. And as you said, it involved the person who was Prime Minister at the time. And in an American publication, things were raised that he had done in his youth. And I report simply what you said, going over the exceptions. At 282.4, paragraph 3, and the conclusion that we arrived at shortly after having received those complaints is that it fell under one of those exceptions, and that therefore there was no infraction committed to our act, and that the file should therefore be closed because there hadn't been an infraction. So there was no contravention there. I would like to refer to the complaints that you received directly from the public for the period of 2019 or for the elections in 2019. What can you tell us in a general way about the experience of the office in terms of receipt of complaints directly from the public regarding allegations of foreign interference? Answer. I can say that we received in 2019, you've gone over the figures a little earlier with Madame Simard, we received a great number, 200, but what is important to bear in mind is that a number of those complaints there's a phenomenon of what we call amplification. A number of citizens will approach us and file a complaint with regard to something that already exists. So the figures that I have in mind may not be exact, but in the case of the article that we talked about in Time, there were some 100 odd. I think that there were also 31 or 32 that were based on an intervention made by a Swedish citizen during the elections, Madame Thornberg, who came here and made statements in Montreal and in Vancouver. And thirdly, there was another incident involving Time magazine where people trafficked in the cover of the magazine in a way that, or dealt it with. So we looked at those complaints, and when we looked at the three of them together, I think that we came up to 160 complaints thereabouts out of the 200. So the point here is that, yes, the figure of 200 may seem considerable, but in fact it is reduced to 15 different allegations with regard to the 2019 elections. Question. And if I take another file, the file which has CEF, a number of zeros, and 17. And here, if I talk about a file which is an example of a tweet from a former American president who was talking about political party. Do you remember this file? Yes, exactly. Can you talk about your decision-making process here? We received complaints. I don't know how many. Were there various? There were some 30 odd, I believe. So people alleged in communications with us that there was foreign interference in quotation marks, due to the fact that a former American president was getting involved in the campaign. And once again here, very quickly we came to the conclusion that fell under one of the exceptions in 282.4, and it was one of the files that we closed very quickly. And I can mention that during the following general elections, the same person, Mr. Obama, emitted a tweet, and we came to the same conclusion, obviously, at that time. And here, you studied or analyzed those complaints, those allegations. This is question, sorry, under from the perspective of 282.4, which is the undue influence of foreigners. An American president who supports a candidate or a political party, it is not forbidden by the law. It's not forbidden. If you look at the three exceptions provided for in subsection 3, be it an American president or an ordinary citizen from France or whatever country, the status of the individual has no impact. The thing is that a person from a foreign person intervening in this way, you have to look at the exceptions, and when we did that here, we arrived at the conclusion that the exceptions applied, so that there was no contravening of our act. Question. In 2019, I understand that clause 282.4, it's a hard one, right? Yes, I'm having a hard time with that. I understand that it was relatively young as a clause. It was the first elections in which it was applicable. Were there complaints or examinations or civil action taken on with regard to that clause? Response: there were no prosecution or no court actions. Question: so there were a number of complaints, but they never led to legal action. Correct. Response: and I mentioned earlier, and it's worth going over it quickly, that for many people well-meaning and reasonable ordinary Canadian citizens, when they see things like this, they say to themselves that a former president of another country says that they can do that. That has to be against the law. There must be something we can do to stop that. Obviously, as Madame Simard wrote, the commissioner operates within the parameters of the law, as it must be, and not as some people might consider it to be. And there are people who are skeptical given in the light of the decisions made. So the response, if there is one, is that obviously would be to change the act, but that's not my area. A question from the Madam Commissioner. One can imagine cases, for example, where a foreigner, be it a former president or another person who's a foreigner, makes that type of tweet or makes a comment on Facebook, and that it does more than simply say that they support a particular person, but provides certain information, taking for granted that some of that information would not be true. Let's assume that. Would your analysis then be able to follow two paths? First of all, questioning whether it's an infraction for that person to support a candidate, but then to look also at the content of what is said to see if there's any information that could be disinformation or misinformation. Response, Carolyn, would you like to answer? No? You're raising a very good point, Madam Commissioner, and obviously we would have to look at the content of the allegations or the statements that are made in the case that you're giving from a non-Canadian citizen. There are at least two issues that would be raised very quickly. First, and 282.8 of the Act, where it's mentioned that it is forbidden to exert pretexts or trickery to lead people to vote in a certain way, and that obviously applies to everybody, be it in Canada or outside Canada. Everyone is subjected to that on the one hand. And then there's Section 91 of the Act, which says it's an infraction to communicate during an election period some types of false information regarding candidates or people associated with parties in order to influence people in the exercise of their voting rights. And question, and that applies both to foreigners as people in Canadian territory. Response, if I remember correctly, under Section 91, subsection 2 or something, that it stipulates that clause applies regardless of where the statements are made. If I may add, says Madame Simard, just taking an additional step, a false statement is very limited. We're talking about false statements regarding citizenship, of the place of birth, studies, qualifications, and or otherwise having committed an infraction to the law. Or so it's very limited. The scope is very limited. Question. So if there were false representations that had to do with like a made-up story, if you will, regarding a candidate who may have taken part in illicit activities or whatever, it might not be covered by that clause. You have to determine whether there was an infraction or not according to what response. I will answer in the affirmative regarding Section 91, but there may be other clauses that would apply as well. Question. Thank you. Question. So be it an American president or a person regarding the allegiances or the relationship with Canada, that doesn't change anything with regard to the individual and their relationship with Canada, be it an allied country or a more hostile country. Response. You're talking, Maitre Ferguson, about question under 282.4. Response. Yes. Question. And now, in 2019, Mr. Cote, during your mandate in 2019, did you lead an investigation into allegations of irregularities during the nomination, Liberal nomination in Don Valley North in 2019? Response, in 2019. Question, in 2019. Answer. Question, or did you have... We heard evidence this morning to the effect that you received a referral from Elections Canada. When I say in 2019, it has to do with regarding the 2019 general elections. Answer. You want me to take the question? Yes,
we have
Madame
received complaints,
Gigoux.
including referrals related to the Liberal nomination contest in Don Valley North. Some do not involve allegations of foreign interference. Information regarding the ongoing review initiated by the Commissioner of Canada Elections has been shared with this public inquiry, and we continue to receive information and assess it as part of our ongoing review.
Okay. But the question was more with respect to the referral that Elections Canada that sent to the OCC in 2019.
So your question,
I understand there's an ongoing review, but I'm speaking specifically of an ongoing review initiated by the current commissioner, but I'm speaking about a referral from Elections Canada in 2019.
Are you, so my question that I'm seeking clarification, are you certain of the date being 2019, or are you referring to the 2019 Liberal nomination contest?
Correct,
and a
correct.
referral that may have been subsequent to that, but not necessarily in 2019?
If my question was unclear, then you have the proper understanding.
Okay.
Yeah.
So we did receive a referral from Elections Canada related to the Liberal nomination contest.
And do I understand that referral had nothing to do with foreign interference?
That's my understanding, yes.
Okay, thank you. Maintenant, si je passe à 2000.
Question. Now, moving to 2021, the elections, and this will be the last part. Mr. Cote, I understand that if I refer to file CEF, a number of zeros, 157. Here, can we reduce it somewhat so that we can see the entire document? Thank you. We're talking here about a summary covering 3 complaints from the same complainant. One of them has to do with the statement from the ambassador of China in Canada, to Canada, in the Hill Times, urging people to vote for the Conservative Party. That's what's summarized in that document produced by... After the examination, the affair was considered to be covered by one of the exceptions under Article 282.4. Once again, I understand the comments of the dignitary for or against a candidate, or for or against a political party, openly or covertly, that did not engage their responsibility under 282.4.
Ferguson, pour être un peu plus précis, je dirais que
maybe, Mr. Ferguson, to be more specific, I could say that the analysis we did of the ambassador's words led us to the conclusion that those words in particular came under one of the exceptions of paragraph 3 of 282.4. Question, then I would refer you
Je vais procéder un deuxième dossier, le CEF, plusieurs zéros, 156.
to the next file.
Puis, Monsieur Côté, this matter involved complaints received during the 2021 general election over a lunch event for the Liberal Party candidate in Vancouver East, which is the electoral district of Jenny Kwan, who is a party to these proceedings.
Oui.
Can you tell us a little about this matter and the disposition in this file?
Absolument. Donc,
Absolutely. We were contacted first, if I remember correctly, by the person who was acting as legal advisor to the NDP, or in the NDP campaign that we're talking about here. So they wrote to us to communicate the fact that there was a lunch that was organized, and according to the allegations in the letter, if I remember correctly, would have been paid for by a man whose name is Chinese sounding, and the way that the complaint was drafted brought to our attention that there were probably violations to the rules of political financing, given that it could have been perceived as a contribution from this person to the candidate's campaign. So I'll come back a bit. We're talking of the Liberal candidate. I think the name is there, Van der Wies. And I think when we tried to find the facts about this, we learned that it is the candidate who had approached Mr. Kwok to tell him that the candidate, would like to be able to meet some Chinese people to get more familiar with them and to get known in the context of the campaign. So for me, it's an important point. That is, it's a candidate who approached that person here. Mr. Kwok in question was described in the letter by the lawyer of the party as someone who was associated to some organizations involved in the fight against racism, against people of Asian descendants. So there was nothing in here that brought me at the time, or brought our investigators to think that there was something undue, especially when we considered the fact that we had described Mr. Kwok as I just did. So we obtained information, and the information we got was along the lines that the sums paid by Mr. Kwok for this banquet were about $1,500 roughly, and eventually the file was solved by imposing only a few weeks ago by Commissioner Sima financial administrative sanction against Mr. Van der Wies' campaign for having omitted in the filed reports this non-monetary contribution that his campaign had benefited from. Question, and I understand that this file was settled under your mandate, Mrs. Sima. Answer, yes, that's correct. Question, if I cover last file with you, Mr. Côté, file CEF 159.
This file involved a complaint submitted during the 2021 general election that expressed concern that foreign agents affiliated with the Chinese Communist Party may be interfering in the election. The complaint enclosed 3 screenshots of social media in Chinese, social media messages in Chinese. The posts were described by OCC staff as being critical of the Conservative Party and referenced the potential impact of Bill C-282, the Foreign Influence Registry Bill, tabled by MP Kenny Chu. Can you describe what happened in this file and when was the matter closed?
À quel moment le dossier a été fermé exactement, je ne sais pas.
Answer, at what point it was closed, I'm not sure, maybe Mr. Gigot has the information. But I know that it was closed while I was still commissioner. So under my regime, as you said. So it's a file that we examined very closely. A lot of work was done to look into that and read and get translated the posts that were on the social media platform. We looked at those attentively, and we came to the conclusion that, yes, there were some words against, and I think the document mentions it, that there were some words against Mr. Sloan, against Mr. Hsu as well. And we saw in there some people who were stating some things and taking some positions, but we saw nothing in there that went beyond what is acceptable in a democratic debate during an election, bearing in mind always, of course, the measures that we talked about, 282.4.
And I understand that there was extensive open source research conducted. I think it's mentioned in the document at steps taken, the last step. There was extensive open source research conducted. This is a topic we discussed during the interview, conducted by an OCC analyst that identified ties between individuals related to the posts and publications and ties to China-based entities with potential links to the Communist Party of China. Is that correct?
Oui.
Je comprends aussi que
question, I also understand that the document could not identify
evidence to substantiate the elements constituting the offense of undue foreign influence?
Oui.
Okay. Là, est-ce que ce document-là,
Answer, yes.
le document the open source product, a été préparé
Was this document prepared by one of your analysts and shared with your partner agencies? Answer, this was not shared by us with our partners. There's one thing that we have to bear in mind. This is a consideration, is the fact that we perceive ourselves, and Mr. Simard can confirm, but we see ourselves first and foremost as an organization receiving complaints, receiving information, and not as an organization whose mandate would comprise distribution or communication of information coming from us to others. Question. Having said this, you still signed a memorandum of understanding with the RCMP that plans for this bilateral information sharing relationship. Answer. So I didn't look at the reports or analyses done by our specialist here, and if I remember properly, they were very lengthy, but the presumption that I have would be that the people in charge of the file in our office, the investigators in charge, I know their names, I know their backgrounds. These are very smart people who have, at least for one of them, are trained in law and have there's former members of the RCMP. So if they saw something that should have been communicated, I can presume they would have come to me and would have asked the authorization of the commissioner to share that information with the RCMP. And Mylène, I don't know if Madame Gigou, sorry, if there was something to add.
I think on this specific matter in terms of the open source research, I think one of the considerations that could have also have applied, and I say that I wasn't specifically there during that time, but the information was reproduced based on open source research. So it's information that's available to other organizations as well in terms of open source. But as the former commissioner mentioned, if there was something, for example, in another instance where we deemed that there was a significant threat in something that we saw, we contacted the RCMP so that they were aware of those issues. So in those circumstances, we certainly do in some, but given our confidentiality provisions and our independence as well, we, as he explained, this is something that's very case-specific and fact-specific when we do seek authorization from the Commissioner of Canada Elections to share with another agency.
Okay. And je vais terminer avec les
question, and I will conclude with the examinations following these allegations of foreign interference, with some coverage in the media in 2022 and 2023. That's under your mandate, Mrs. Simard. You initiated an examination following allegations communicated to you. I will speak of a first file that is something that we mentioned together during the interview. So I'll call up CEF 161. And could you briefly describe this file? Answer. Yes, this is a file that I opened on my own initiative following some allegations expressed in the context of a parliamentary committee. So in the summary, it's indicated that it was the PROC committee. And if I summarize very simply, some examination work was done, some witnesses were met, and at the end of the day, there was no reason to take it any further. So I closed this file. Question. Okay, I understand there are two other investigations ongoing that were initiated by yourself. Answer. Two examinations, yes. Yes, excuse me. And I'll call up CEF 152. And So that is the first file. I understand it's an examination following allegations about some ridings in the Greater Vancouver region. And another file, CEF 150, I think it was mentioned earlier. So an examination into allegations linked to the Don Valley riding, amongst others. So I understand that beyond those summaries, there's nothing that you can say since those are ongoing. Answer, yes, absolutely. So the first one is following around 50 complaints. So it's ongoing, and the second one was of my own initiative that it was opened up, and it's still ongoing. And indeed, I cannot tell you more than what's here. So already, it is very exceptional to share this kind of information. You will understand that there are different reasons: presumption of innocence, privacy, investigation techniques, etc. And I would take a couple seconds to say that we are operating in a very specific environment compared to others. It's very much a partisan environment, and the last thing we want is to be used as an instrument to feed that partisanship. So it's very important to preserve confidentiality in that context. Question. Thank you. And last question. I asked the question to Mr. Simard. No, it's getting late. Mr. Côté earlier about 282.4. That there hasn't been any prosecution following these allegations and complaints around the elections of 2019. Were there some for the elections in 2021? Did these measures lead to any prosecution? Answer. When I left in June 2022, there hadn't been any, no. And it's still the case, Mrs. Simard? Answer, yes. So thank you for your time. I have finished my questions, but there will most certainly be questions from other parties. Thank you, Mr. Ferguson.
I suggest that we really take a short break just for what is needed. So 5 minutes, and we'll come back for cross-examination.
Order, please. À l'ordre, s'il vous plaît. The hearing is in recess until 5:20. La séance est en pause jusqu'à 5h20. Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
I'm sorry, Commissioner. We are missing one of our witnesses. I believe they're coming in very shortly, but we'll just pause for a moment before beginning.
Maybe we can apply when she.
Commissioner, I wonder if it's Gib Van Aert here, a procedural matter that I don't think affects a witness. I wonder if I might just, it's a bit late in the day to be asking questions about procedure, so maybe I'll table it for tomorrow. But I wanted to flag for you that I did have some guidance that I'm seeking from you about the proper use of the interview summaries in light of the comments that Mr. Shepherd raised. I haven't had a chance to talk to Commission Counsel about it first. So what I propose is to talk to Commission Counsel. If we're not able to work it out, I might ask for guidance from you first thing in the morning rather than burdening us with it now.
Perfect, but I invite you to discuss with them and then you'll see.
Thank you.
Est-ce que vous siégez demain?
No, we are not sitting tomorrow.
Yes, I'm just being reminded of that, but we could do it on Tuesday morning if need be.
Yes.
Hopefully there won't be a need.
You can go ahead.
Merci, commissaire.
Thank you, Commissioner. Ladies and gentlemen, to begin with, I would like to give a summary of what I understood from your evidence, and I'm looking at Mr. Côté in particular, but I would invite you, the three of you, to speak up if you want to. But I would like to understand the scope of the Act and the contraventions under the Act and their overlap with foreign interference. If I understood you correctly, without going into all the details, if I understood correctly, that there is some possible overlap between the contraventions provided for under the Act and the idea of foreign interference as we understand it and as the Commission is reviewing it. But even if there may be some overlap from time to time, it is also the case that the idea of foreign interference as defined by the Commission seems to be broader, and as a result, it is not clear. Well, so maybe it is clear that it is not the case that any instance of foreign interference might be a violation of the Act. I know that I took a lot of time to explain this, but do you understand? Answer. I think that I understand, and I quite agree with you. Answer. Thank you. Question. And I might add, if I understood correctly, even if the Act had other contraventions and a greater scope, there would still be two issues. First, the contravener may not be in the country. Isn't it true? Answer, yes, he or she may not be in the country, but sometimes and often it's impossible to bring that person into the country. Reply, yes, thank you, I agree. Question, and that's a legal matter, but generally, our criminal laws cannot be implemented extraterritorially outside the country. This is something that Parliament can adjust, but that's another challenge. Do you agree? Answer, yes, that's correct. Question.
Who, if I may. Commissioner, here I may be about to stumble on the procedural question that I was going to raise, but let me see if I can do it without raising the question, and my learned friends will raise any concerns they may have. Ms. Giroux, I wanted to ask you, was there a meeting between CSIS and the CCE, an urgent meeting, on the Saturday before the polling day in October 2019?
I believe that's reflected in my witness statement.
I believe it is too. Yes, thank you. In your witness statement, and I don't believe I'm seeking to contradict the witness here or impugn her testimony at all, so I don't believe I need your leave, Commissioner. But you referred to this, and in fact it came up in Maître Ferguson's examination as well. You referred to something called the One Vision process in connection with this. That is to say, if I recall correctly, you said that CSIS called on CCE in this urgent way according to a One Vision process. Can you explain what the One Vision process is, please?
This is a process by which CSIS shares intelligence with our office.
Just with your office?
Essentially, in this, it could be with other organizations, but certainly it's, if I understand correctly, it's a model that's also used with the RCMP. And obviously, we're not as mature as an organization as perhaps the RCMP, but essentially a process by which information is shared with our office.
Thank you. And I understand that this meeting might have resulted in the preparation of a use letter.
As it states in my statement, yes.
Thank you. Could you tell the Commissioner what use CCE may permissibly make of intelligence that is the subject of a use letter?
So without the two letters that our office has received are for intelligence purposes only.
Yes, I understand that, and you explained that to my colleague, Mr. Ferguson, earlier. So you can use it for intelligence purposes only, but of course, you're not an intelligence organization per se. I want to understand better what use you put it to.
So essentially, none of the information, given that it was provided for intelligence purposes, would have been used as information to support any investigations if one was undertaken, or a review, I should say, a review or investigation.
Understood. Okay, thank you. That's very helpful. In other words, you have this intelligence, but you can't turn it into evidence for the purpose of investigating or enforcing a potential contravention of the law.
That's correct.
Thank you. I'll ask the court operator to call up document CF 0000158, please. Thank you. And I'll invite anyone to answer this question. I understand that this is a complaint that was submitted that was alleging that Chinese agents were urging people not to vote for the Conservative Party of Canada. This was in connection with the 44th election. And that the Commission determined that there was nothing violent or offensive in the language that was at issue, and closed the file. Is that right?
Pas tout à fait, maître.
Not quite. The question was not to know whether there was violent language or not violent. It was to determine whether, upon reading these posts, we could conclude that there was a violation of the Act, and we determined that the exchanges were sometimes strong, sometimes the language was offensive, sometimes people were going back and forth, but in the end, we determined that even if some strong language was used, and I would like to draw your attention to the second bullet.
They did not identify any overt threats of violence. Ça, c'était évidemment nos enquêteurs qui sont arrivés à cette conclusion-là.
That's what our investigators determined. Thank you for this precision. So, how was the fact that there were no threats of violence was relevant in this case? Answer. If there were threats of violence that were clear, or real threats of violence or threats to people's integrity, depending on the context, on the evidence, on people who were targeted by such threats, we might have been in a situation in which there may have been a violation under Section 282.8 under pretense and contrivance. Question. I will go back to the second sentence.
On Chinese language social media forums, that foreign agents on behalf of China were trying to manipulate the election by offending the Conservative Party, stating Chinese people would be killed, and included some screenshots. So, si je vous ai bien compris, vous avez...
So if I understood correctly, you considered the complaint and you determined that this was not coming within your purview under the Electoral Act, so you had to close the case. Answer. Yes, and if I remember, what I remember from the case is that our investigators worked very carefully. The posts were translated by professional translators, and the investigators sat down with the complainant to review the translation, to make sure that the translation was faithful. And if I remember, it may have been edited here and there. But after this translation and the exchanges with the complainant, we reached the conclusion that you just mentioned, is that there had been no violation in that case. Thank you.
The next document, CEF 059.
When I took office in 2022, there were allegations in the media very quickly. There was a media storm. And in this context, and when I appeared before Parliament, I said that we would leave no stone unturned. So our staff went back to close cases to see if there could find any other evidence. And that's one of these examples. In this case, we really tried to do additional work in spite of the fact that the work had been done very well in the past, but it was under new circumstances, and we reached the same conclusion, and the case had to remain closed. Thank you. You've used up your time, but I will allow you to ask last question. Answer. Thank you.
I'll finish with this, and I won't need the document now. Thank you. Even if the Canada Elections Act were amended to introduce broader prohibitions and cover some of the kinds of foreign interference that are not presently covered, do you agree with me that the time that it would take to receive a complaint, investigate it, determine whether it had any merit, and then proceed to enforcement would take much longer than the writ period, and no enforcement could possibly be done before Election Day? Anyone?
Moi, comme je ne suis plus en poste, je préférerais peut-être que...
Since I'm no longer in office, I would prefer for my colleagues to address the question. Considering that we only have little time, I don't know if Ms. Gigou would like to speak.
Do is achieve compliance as quickly as possible when a variety of scenarios present themselves. We try to equip ourselves as best as we can so that we can respond swiftly, quickly. Obviously, we also want to make sure we're not making mistakes as well. So robust investigations or reviews can also take time.
Well, I'm sure all of that is true, but it's not an answer to the question I asked. The question I asked was, do you agree with me that even if you had powers to enforce against some of these other kinds of foreign interference that we are considering here, it would just be, practically speaking, impossible to receive a complaint during the writ period, make a determination, and do something about it before Election Day? And we're talking about a space of 45, 50 days, right?
Alors, ce que je vous dirais, c'est que ce que vous exprimez...
What I would say that is that logically, yes, it would be difficult to do that, but once again, I think that it's worth a try. That's what I would say. That's what I would like to see.
Counsel for Erin O'Toole.
Thank you, Commissioner. This is Tom German. I'm the counsel for Erin O'Toole, and I've just a very few questions. When investigators receive a report or are given a report to investigate, has there been any standing direction given whether or not they screen the file with respect to possible threats under either the Security of Information Act or violations under the Security of Information Act or the Criminal Code?
Alors, de façon générale, c'est la loi...
Generally, it's the Canada Elections Act's contraventions which apply. Some provisions of the Criminal Code may apply if they are related to the offenses under the Canada Elections Act, for example, for fraud, for example, for political funding. So we could also use the clause for frauds under the Criminal Code. That's only an example.
I'm thinking in particular of Section 20 of the Security of Information Act, which makes it an offense for the direct benefit of a foreign entity to act to induce by menace a person to do something that would increase the capacity of a foreign entity.
So I think maybe you should rephrase your question. I see the witnesses, they are just trying to understand what you're looking for.
So Section 20 of the Security of Information Act says every person commits an offense who, at the direction or benefit of an association with a foreign entity, induces or attempts to induce by menace, and I removed the words reflecting violence, etc., a person to do anything for the benefit of, to do anything that increases the capacity of a foreign entity. So when a foreign state actor causes or threatens further to, for example, CEF 158, potential violence for the benefit of a foreign entity, has direction been given to apply Section 20 or to report that to another organization? I appreciate you can't charge under SWOIA.
Alors, je vous dirais peut-être dans des termes généraux, je reviens.
So generally speaking, I will come back to the Canada Election Act, and the provisions of that act would apply. And I would say that, as far as I know, this is our framework. There are a few exceptions in relation to the criminal code that I explained earlier today. I'm turning to my colleagues to see if they might want to share additional information.
So perhaps just to supplement Madame Simal's answer, if I understood correctly, you asked if it was triage with that lens as well. So if that's the case, if that is in fact the question, so the triage that's done by our intake unit is done with the lens of the Canada Elections Act, as Commissioner Simard has mentioned. If something falls within our mandate and it's being reviewed or investigated by investigators, and that they have, we work in a small team with experienced investigators, and we also work very closely with our internal legal services as well. So there may be discussions about whether there could be, for example, the application of the criminal code or things like that. There could be those discussions, but there's no specific instructions that I am personally aware of within our office with regards to the Security of Information Act.
Thank you. Those are all my questions.
Thank you. So I think next one is Jenny Kwan. So it's Med Choudhury.
So, Commissioner, I think I'm going to walk into this procedural issue that's been flagged. So I would like to ask some questions of the panel regarding the Vancouver East luncheon that has been the subject of a CC investigation that Mr. Ferguson asked some questions about. And both of the the interview summaries address that luncheon over a few paragraphs. And I'd like to seek your leave to pose some questions specifically in relation to the investigation of that luncheon, as the evidence is described here, because it's a bit, the evidence that's in the in the interview summaries is a bit more expansive than what Mr. Cote was able to do.
And you want to draw their attention to what they said actually,
I think,
what is reflected in the summary?
I'd like to, yes.
Okay.
Commissioner, I wonder if we can assist to clarify the rule in respect of the witness summaries, that certainly in cross-examination that counsel is entitled to refer to the witness summary. Where leave is required is where they're going to cross-examine in the sense of put some inconsistency. You cannot put inconsistencies to the witness from their summary. I'm sorry, I'm not speaking clearly at the moment, but leave is not required in order to refer the witness to a portion of the witness summary.
Fair enough. So I think we're all on the same page. Then I think Mr. Van Oort and I were using them in the same way. So let me begin then by asking that the following document be called up on the screen, please. It's JKW 4082. And if you could scroll down, please, to page 3, actually above, yes. So this is an email, as you'll see. It's from an investigator at CCE, as I'll call it, and it's to MP Kwan, and it's dated July 2023, and so it's a request to have a discussion regarding a complaint that she had lodged, and I'd put to Mr. Cote in particular, but to the panel, that this is the complaint that Mr. Cote referenced in his testimony in 2021.
It looks like it, yes.
Yeah, okay, good. So I'd like to now call up JKW 4083.
Sorry.
I'm sorry, yes, ma'am.
If I could perhaps just clarify your question at the bottom, just to pull up again, the bottom message, please?
Sure. Excuse me, can we go back to the previous document, please? Thank you.
So that email of Monday, July 17, 2023,
Correct.
you're suggesting that it relates to which file number, please?
Well, it relates to a complaint that was lodged by Ms. Kwan during the 2021 campaign.
Do you have the file number for that? Because I don't believe that's the, it relates to those allegations.
Well, I can, that document's not been put, well, actually, Mr. Ferguson, I think you did put that document up on the screen.
So if you are referring to CEF 156,
I believe that's the document that that Mr. Chaudhry is referring to.
the inquiry, the email to Ms. Kwan was not for that purpose.
I see it, but can I take you then to the next, the exchange of correspondence with Ms. Kwan? So I'd like to take you down to Ms. Kwan's email and stated August 10th. So if you could scroll down, please. And so I just want to spend a bit of time on this email. And so the first thing I'd like to note is that at the bottom of this page, Ms. Kwan cuts in, sorry, if you could go up a little bit slowly. There's italicized text. Good. Okay, just a bit more. So what Ms. Kwan has cut and pasted into this email back to your investigator is correspondence that her team sent to CCE back in October of 2021 regarding pricing at the restaurant where the lunch that was the basis of her complaint back in 2021 was held. And if I could just summarize this here, the reported cost of that lunch, as has been said by Mr. Cote, was $1,500. And Ms. Kwan's team did a market price assessment of what a lunch of that size should have cost. And the cost should have been, for the number of attendees, between $2,500 and $3,000. And so Ms. Kwan, and this was presented to CCE at the time, and Ms. Kwan will testify that there was no follow-up on this issue until July 2023. And then if you could scroll up, please, slowly, a bit more. Stop there. There's a paragraph here which says, when I brought the Fred Kwok matter, that is the lunch, up on the telephone call with you recently, your response was that you are less interested in this issue with your visit to the Lower Mainland. But I would like to point out that following this complaint and in light of the revelation from CSIS that I'm a target for foreign interference, which is a matter of public record, it would be important to ensure that there be a thorough investigation on this matter to ensure that no foreign interference or violation of the Election Act has taken place. And so then I'd take you down to further, if you could scroll down to the next page again. I'm sorry to be jumping around. Look at this paragraph here that begins, to date. To date, we have not received any information from Elections Canada, by which she means CCE, regarding the conclusion of their investigation. Recent news coverage of CSIS leaks has brought to our attention alleged involvement and interference by the Vancouver Chinese Consul General in the 2021 federal election. The media has also reported on a scheme conducted by the Toronto Chinese Consulate, which funneled funds through community figureheads into election campaigns. These reports have reminded us of the Fred Kwok incident and brings to the forefront the lingering questions we have regarding the luncheon we hosted for the Liberal candidate during the 2021 election. That's a typo. And so my question then, based on this letter, is this: if in fact the Vancouver Chinese Consulate had provided funding for a lunch where a Canadian citizen hosted for a political candidate during an election, would that not amount to a violation of Section 282.4 of the Canada Elections Act? Would that not amount to undue influence by foreigners?
Alors, je commencerai la réponse en vous disant peut-être.
Answer. I will begin response by saying here that this is a file that was born. And in terms of the facts, what is important to remember is the initiative of the candidate who held a luncheon. And this file is one for which a decision was brought down. So a decision of an administrative nature, an administrative sanction, a fine was imposed to the official agent for a non-monetary, undeclared contribution in the amount of $500, and that amount was paid. So for us at the office, this is then a file regarding a non-monetary contribution which was not declared.
Decision that was taken, but that wasn't my question.
Oui.
My question is simply this. If the Chinese consulate in Vancouver contributed funds to a lunch hosted for a candidate in the 2021 federal election, would that not amount to undue influence by foreigners in contravention of the Canada Elections Act? It's a simple question.
Oui, mais vous comprendrez que pour analyser une question.
Answer. You will understand that in order to analyze a question such as that, you have to look at the provision a little more closely.
I would add to the Commissioner's response as well that although there's allegations, no one has provided specific information that the money paid for the lunch was from anyone other than Mr. Kwok.
Well, I'd like to get to that, but I'd like it noted for the record that I posed a question about whether payments by a foreign government to host a luncheon for a political candidate would violate the Canada Elections Act, and I did not get an answer from the panel. So I now would like to move on to the investigation that was conducted. So I realize that I think you've said, well, there is no evidence that the funds came from a foreign government. So I'd like to take, if I could, to witness statement 6. Actually, pardon me, witness statement 25, page 18. That's paragraph 96. So let's look at paragraph 96.
Whose statement is this?
This is the statement that was provided by Côté, Juju, and Mathieu. So I believe this is yours, sir.
Merci.
And so if I could look at the last two sentences of paragraph 96, it says, the organizer of the lunch indicated through his lawyer that he paid $1,500 for the lunch. The restaurant in question refused to provide a receipt of the lunch. And so I'm to assume that you did not use any powers available under the Act to demand that documentation.
Alors, pour répondre à cette question, je comprends que la question...
Answer. To respond to this question, you'll understand the question is addressed. We're in an administrative context. In an administrative context, we do not have the tools that are available under the criminal regime. So, as a result, there is no power of an order of communication existing. That is, I would say, one of the shortcomings of the regime as such under the Act. In terms of administrative powers, that simply doesn't exist.
To demand that documentation.
Tout à fait, en vertu du régime administratif.
Answer, absolutely, under administrative context.
Walk appear for an interview.
C'est-à-dire, il y a un pouvoir de contraindre les témoins.
Answer, there's a power to testify. And once again, if I may allow myself, it's appropriate to remember the facts. The context in which we're acting, that is that in this file, it's the initiative of the candidate. So we're in a position, in fact, where you have to appreciate the facts. And the facts here are that we have somebody who's a Canadian citizen and who pays for a lunch luncheon, and therefore I cannot speculate here. But it's important to remember once again that this is a Canadian citizen.
Commissioner, I'd put it to you that given that you had no evidence from the individual in question who organized the lunch or from the restaurant, you are in no position to dismiss the allegation that there was potentially foreign interference through funding for the lunch, where there is a gap between the market price for the lunch and the amount that was reported by the organizer. And you didn't have the tools to find that evidence. So rather than saying there was no foreign interference, at most you could say you're unable to conclude that there was no foreign interference. You couldn't reach a conclusion either way.
Alors, si je peux me permettre, si vous voulez avoir une réponse complète.
Answer. If you will allow me, if you want a complete answer, I will turn to my colleague to see what may have been done. And my investigative work was carried out when I entered into the position. I can speak for myself and say that before providing the decision, once again, I'm in an administrative context, and I do not see. That is that it's the candidate's initiative, and we're in an administrative context. There are partners who are doing their work and who in whom we have trust. We trust that they are doing their work properly. And this is limited. It's within an administrative context.
A statement and with...
Chaudry, je veux juste vous prévenir, je vous ai déjà laissé pas mal plus de minutes. Je vous laisse
Intervention. I would just like to remind you, I've given you quite a few more minutes, and this I would limit you to this last question.
So if then in this case, I'd like to take you to I'd like to put into the record, because I don't have time to refer to them both, CAN 1088 and CAN 1075. And in particular, I'd like to take the panel to CAN 1088. So this is a site rep or site report that is contemporaneous with the 2021 federal election. It's dated September 16, 2021. And if I could take you to page 2, you'll see that under the, if you could go down. Oh, and I have the wrong page up. Hold on a second. Pardon me, it's on page 1. You'll see in the second bullet point, there is a reference to the lunch. And it says there is a campaign event for the LPC Vancouver East candidate that promised a free lunch hosted by a pro-Beijing individual with connections to China. Now, am I to assume, is it fair to say that this document, you've never seen this before?
I did not see this until perhaps earlier today. I'm not sure if this is a document that was flashed to me a bit earlier, a few hours ago.
So had you seen this document when you received MP Kwan's complaint, might you have considered her allegation of foreign interference differently, given that another arm of the Canadian government flagged that event during the election and raised the concern of possible links to pro-Beijing elements?
Et la question, c'est celle de savoir si...
And the question is to know if
Could I restate the question, Commissioner?
Yes, you can
Yeah.
repeat the question, yes.
So the question is this, that contemporaneously during the election, a specific body designed to detect potential foreign interference flagged the very event that was the basis of a complaint to your office as raising a sign, a potential sign of possible foreign interference. So I'm using those terms carefully. We're not saying there was, but we're saying there might have been. And had you seen this intelligence report when you received the complaint from MP Kwan's office, which happened during the election, would you not have perhaps considered the possibility of foreign interference a bit more seriously than you have?
C'est la toute première fois que je vois ce document.
Answer: it's the first time I see this document. What I would say is that clearly our investigators would have taken into account and considered the contents with the information and allegations in this paragraph, and it would have been part of the analysis of the file they would have done, and it might have brought them in the same direction or in a different direction. Thank you.
I think it's Mr. De Luca acting for, representing the Conservative Party.
Good afternoon. In the interest of the limited time that we have, I'll direct the following questions to Ms. Simard. I will ask that she answer, but in the event that either of you, Mr. Cote or Ms. Gigou, would provide a different answer or something further to add to Ms. Simard's answer, I will pause and give you an opportunity to supplement, but otherwise I'll assume that you accept each other's answers. So first question, as set out in the website of the Commissioner of Canada Elections, it indicates that the Commissioner and her staff are to work to ensure that political entities, third parties, and other individuals and entities engaged in the electoral process do so in compliance with the rules. Do each of you agree that this is the mandate of the Commissioner?
Yes.
Ms. Simard, if a Canadian corporation or trade union began paying staff to promote or oppose a candidate in a federal election, would that be within the scope of your office or your mandate to review and investigate?
Oui.
And am I correct that as a general proposition, that sort of activity by a corporation or a trade union is offside the Canada Elections Act?
Je vous dirais.
Answer: I would say we're talking of third parties, so yes.
I trust that in those circumstances, i.e. where a corporation or a trade union is actively paying staff to in effect campaign in a federal election, that's an investigation that you would pursue aggressively if there was evidence to bear it out?
Je vais me tourner vers.
Answer: I will turn to Mr. Giroux.
So just to clarify, the Canada Elections Act is extremely complex, and hypothetical fact scenarios at this speed, and I have difficulty answering at this time. We work in a small team where we work very closely with legal counsel as well to ensure that the specific facts that were presented, whether they square within the parameters of the Canada Elections Act.
But generally speaking, I'm correct that corporations and trade unions cannot be actively campaigning or certainly expending funds in support of campaigning. Isn't that correct?
There are rules governing those activities.
As a general proposition is what I've asked you, correct?
Yes.
Thank you. And am I correct just by way of example, if you recall, in or about May 2020, the commissioner entered into a compliance agreement with the company Norda Steel Inc. to ensure compliance with the Act, and that was an investigation that related to attempts to circumvent the contribution rules under the Act?
So you said May 2020?
Yes.
Ça s'est produit pendant que j'étais en poste.
This happened while I was there. I have no particular memory of the transaction that you're mentioning. So I presume that what you're saying is correct, but
Enforcement steps have been taken against corporations or trade unions?
Oui.
Thank you.
yes,
Ms. Simao, do you accept that foreign interference by state actors is a threat to Canadian democracy?
Oui.
yes,
Would you accept that although it may be difficult to trace, that when state actors perpetuate foreign interference, they do so using staff of the state or operatives of the state?
I guess among other things, entre autres choses, oui.
amongst other things, yes.
Agree that it is part of your obligation and your duty to pursue unregistered third-party spending to the full extent of your mandate, regardless of whether that third-party spending originates domestically or internationally?
Je suis désolée.
I'm sorry, I will come back to the comment of Mrs. Gigou. It is very complex. There's 550 articles. It's very difficult to answer such a question currently.
As Commissioner Simard is answered, sorry.
Sorry, maybe I didn't understand the answer.
Could I ask you as well to maybe slow down just a little bit? I apologize. It's getting very, very late in the day, and
Sorry, the question is essentially this, that your obligations to investigate contraventions of the Act, including third-party spending, don't depend on whether that spending originates domestically or internationally.
so just to be clear, when there are allegations that are presented to our office, a complaint is submitted. If there are allegations that fall within our mandate, we review it. In certain circumstances, we investigate it.
Right.
It depends on the scenario.
Right, but your mandate isn't limited to domestic actors or foreign actors.
Correct.
Your mandate includes both.
Correct.
Thank you. And
J'aimerais, monsieur, si vous me faites...
Sir, if you allow me, I would like to qualify one of the affirmations you made. I do not think that the Act imposes to the Commissioner the duty to investigate. She has the duty of carrying out her functions so as to maximize compliance to the law, but you will understand, I presume, that there are all sorts of things that you can choose to not investigate on because there are other priorities, or because resources are limited, or because the level of severity of the violation is not that high. So I wanted to say that there is no duty to investigate everything.
the responsibility and the authority to do so?
Certainly the authority.
Thank you. Are you familiar with an investigation by your office into a lunch organized by an organization in British Columbia for the Liberal candidate in Vancouver East?
On en a parlé tout à l'heure.
We talked about it earlier, so it is the file Richardson. It's published on our website. There was $500 fine that was paid.
That investigation was opened?
C'était avant.
It was before my time. It was open, sir, if I remember properly. We received a complaint from the lawyer of the NDP around September 10th or 11th. And I think the investigation, I do not remember specifically, but I think the investigation was opened shortly after receiving that, except I would qualify what I said with the following, that during electoral campaign, by definition, the office is always very busy. There's all sorts of things coming to us, and it's rapid fire, so maybe the investigation was launched later. But I think it happened fairly quickly after.
But my next question was going to be, how long did the investigation last, and was it closed? I don't know if you answered that in the last answer. You may have.
Moi, quand j'ai quitté en juin 2022,
When I left in June 2022, I think that the file was not closed yet.
I'm just looking for the date now because the point at which the investigation was closed and the ultimate compliance measure was issued, there is a certain period covered by that period. But that the actual collection phase on June 14, 2022.
Okay. And can you give me a sense of how many investigators were assigned to that particular investigation and how many investigative hours were expended?
Certainement sur la question on the issue of hours, I have no idea. On the number of investigators that might have been working on the file, I think traditionally on files like this, we have 2 investigators who are paired. So I assume that this was the case, but I don't have independent recollection of how it was done.
Ms. Hugo, do you know?
And I apologize, I was actually on secondment at the Public Health Agency at this, for part of this period as well.
Is that perhaps information that could be provided subsequently?
Bien sûr.
Sur la question des heures,
I'm not
je suis pas
sure
sûr que les
whether
heures
we
on soit
can
capable.
quantify it that way.
Can inquiries be made, even if it's on a best efforts basis?
You can try to see.
Madame la Commissaire,
Yeah.
juste sur la pertinence.
Mrs. Commissioner, just on the relevance of doing such an exercise, maybe some objection?
I understand it will be based just on a best efforts basis, yeah.
Good.
No more than that, so they can look and see if they can get the information.
Thank you. I'd like to move on. I've got similar questions to another matter. You familiar with an investigation by your office into matters of intimidation against a Conservative Party candidate by a Chinese consular official?
En fait, je cherche le...
Answer. So you're talking of one file in particular?
WIT multiple 06, paragraph 55.
Est-ce que c'est possible de le montrer à l'écran?
Could we put it up on the screen?
Paragraph 55. So perhaps while you read through that, I have the same questions as before, and to the extent that you can answer them now, that's fine. If not, I'll take an undertaking on a best efforts basis so we don't belabor the point. So when was...
Just to be clear, you want to know how many investigators were...
I'll ask the questions and put them on the record. When was the investigation opened? When was it closed? How long did it last for? How many investigators were assigned to it, and how many investigative hours were expended?
Même, en fait, là, j'essaie juste de me repérer.
Answer. I'm just trying to get my bearings in the time and space on this file, but I will give you the same answer, meaning I will do my best to give you an undertaking on what's available.
Mr. Cote, this one's for you. Were you also the commissioner, or were you the commissioner of Canada Elections when OCCE launched an investigation into certain activities carried out by Rebel News in connection with the 43rd general election?
What was the date?
I believe it was, the election was called on September 11, 2019, and was held on October 21, 2019. I believe the complaint emanated with respect to activities that commenced just before September 11.
Je peux certainement confirmer.
I can certainly confirm that at that time I was the commissioner in place.
Perhaps refresh your memory, Rebel News is an organization associated with the individual whose name is Ezra Levant. Is it ringing a bell?
C'est une question, oui.
Okay. And
Yes.
am I correct that there was an investigation that led to the deputy commissioner issuing 2 notices of violation against Rebel News and issuing an administrative monetary penalty in the amount of $1,500 for each penalty? Does that sound familiar?
Deux commentaires. La première.
Answer, 2 comments. First of all, the link with foreign interference is not coming to me for the time being.
What you're saying about this case, I don't see foreign interference at all in the picture. That said, yes, there was an AMP that was issued against Rebel News or 2 Rebel News for. Yeah.
Okay, and am I correct, Mr. Cote, that you were asked to review the deputy commissioner's decision and you did so de novo?
Je continue à.
I continue to mention that, to my knowledge, there was no foreign interference.
I don't see the link to foreign interference. But yes.
Okay, we'll get to that.
Okay.
And and am I correct that you ended up agreeing with the deputy commissioner's determinations?
As I recall, I rejected the appeal or the request for reconsideration. Yes.
Fair enough. And am I correct that that was in or about July 2021?
I have no specific recollection.
Okay. And am I correct that Rebel News sought judicial review in the federal court in respect of the NOVs and the AMP that had been issued by the OCCE?
C'est ce que je comprends, oui.
Answer, that's what I understand, yes.
The judicial review application was dismissed and your decision was upheld, Mr. Cote, correct?
Oui.
Okay.
Answer, yes.
The Strickland decision in that case was delivered in or about December 2023, correct?
Je ne crois pas.
Answer, I don't think so. I think it was a bit earlier, but I don't have a memory of that.
Had become the commissioner?
Yes, that's correct.
Okay, so am I correct that from the time of receipt of initial complaint, in that case in September 2019, through to investigation, through to administrative action, internal review, and then judicial review and decision, we're talking a period of well over 4 years that OCCE devoted expenses and resources in relation to this one particular instance of contravention of the Elections Act?
Ben là, je veux dire, la question s'adresse à qui?
Who is the question for?
Between the initial investigation and the ultimate conclusion, over 4 years transpired in which your office had to devote resources and time to both investigate and to see it through to a final conclusion. Isn't that correct?
J'ai pas les dates devant moi.
Answer, I don't have the dates here. If the dates you're giving are correct, then the mathematical calculation would be correct too, I presume.
Would it be fair to say that while for investigations of breaches of the Elections Act by domestic actors, OCCE has allocated far greater resources and spent far more time in its enforcement activities than it has in respect of alleged breaches of the Act by foreign operators?
Mais vous comprendrez que dans l'abstrait.
Answer, well, you will understand that in abstract it's difficult to answer such question. We would have to reconcile the work that was done during this whole period. I came into my position in August 2022. It's been a bit over a year and a half, so we'd have to see. To answer you precisely, we would have to look at all this information. What I can tell you is that since I came in my position in August 2022, I said so publicly, every part was overturned. For foreign interference in elections is an issue that I take and my staff takes very seriously. I don't know if it was to you or to the previous lawyer. There was some work that was done about the file that was closed. There are some investigations that were launched of my own initiative, whereas we hadn't received any files with complaints. So everything is looked into, and once again, this issue is taken very seriously.
With respect to complaints that you consider to be related to foreign interference, those are on the whole, dealt with in a shorter time period than other complaints relating to domestic actors?
Je vous dirais que pour ce qui est donc des dossiers d'ingérence étrangère, ce sont des dossiers.
For foreign interference cases, they're usually complex cases. They require time. So the connection between a domestic file and a file of foreign interference in terms of time, well, I don't think that this comparison is adequate. I am not quite seeing the use of such an exercise, but in the foreign interference cases, it takes time, it's complex, there is a lot of work which needs to be done, in-depth work.
To the effect that for the 44th general election, your office received 20 complaints, which you would classify as relating to potential foreign interference, and for the 43rd general election, there were approximately 200 complaints that you would classify as foreign interference based. Is my recollection correct?
That's correct, yes.
Okay. And has OCCE conducted any analysis or formed any views as to why the incidence of complaints in the 43rd general election was 10 times that of the 44th?
Je vous dirais que, en fait, pour répondre à votre question, non, c'est-à-dire de façon générale.
No, generally speaking, but I can turn to my colleagues to see if there is more information.
The points I made earlier when I was examined by Maître Ferguson, and that is that in 2019, yes, we got 201 complaints, but about 160 of them were related to 3 allegations. 1, the Time article, 2, the Time cover, and 3, Ms. Thunberg. So in all, when you look at the statistics for that election, what you find is you have 15 different allegations of foreign interference, though the number of complaints appears to be so much bigger.
That's fair, and that leads into my next question somewhat. How many of such investigations, sorry, let me back up. Do all complaints to OCCE result in investigations?
I missed the beginning of your questions.
Do all the complaints that you receive result in investigations?
In my time, no.
Okay. So, am I correct that there's an administrative screening process or there's some preliminary determination that gets undertaken as to whether or not to pursue it as a formal investigation?
Yes.
Okay. And with respect to complaints which have matured or aggregated into formal investigations, because you mentioned that you can have multiple complaints with respect to the same incident, are you able to help us over the course of the 44th and the 43rd and 44th general election? Are you able to help us with how many formal investigations have been commenced in respect of what you would classify or characterize as potential foreign interference?
I think that the numbers are that there were 3 for each of the 2 campaigns.
So 6 in total over the 2 election periods.
Yes, and Mylène, is that?
That's my recollection as well.
Okay, and
Luca, it's going to be your last question because your time is already exhausted. I gave you a few minutes more, but it will be the last one.
So I'll be selective here. Ms. Simard, earlier in your testimony, you were reviewing the various enforcement mechanisms available to OCCE, and I believe that you used the term that we've heard sometimes as a regulatory toolkit or an enforcement toolkit. One of you did at least. Does that sound familiar?
Sorry, I missed.
The enforcement toolkit?
Yes.
Okay. I don't believe I heard it. I could be wrong. But I'd like to refer you to one of the enforcement mechanisms in the Act, and that is Section 516, which permits the Commissioner during the election period to apply to the court for an injunction to bring an immediate end to a breach of the Act or to require an individual to comply with the Act if the integrity of the electoral process and the public interests are at stake. Are you familiar with that provision?
C'est-à-dire, je sais qu'elle fait partie de la loi.
Okay.
I know it's part of the act.
To your understanding, is this an enforcement mechanism which the commissioner has attempted to avail himself or herself in the past?
Je vais me tourner vers mes collègues.
I will turn to my colleagues.
I don't believe so.
I will turn to my colleagues. Answer.
So next one is Human Rights Coalition.
Good afternoon. My first question is for Ms. Jiku. You mentioned that in preparation for the 43rd and 44th general elections, the OCC worked to establish and strengthen relationships, including with government agencies and academics and other experts. Did you also work to establish and strengthen relationships with diaspora community organizations?
Not to my knowledge.
Do you think that would be valuable?
I think that's something that we certainly have to think about as we plan for future preparation activities.
Si je peux me permettre, donc dans le cadre de la revue qui est
As part of the review that we undertook, following some 50 complaints that we received, we can already draw that conclusion. So since we started this work, that's certainly an inference we can make from the work that has been carried out up to date.
I'm sorry, I missed the first couple words of this. Are you saying that this would be valuable, that that's the inference?
Yes, that's basically what I said.
Okay, thank you. My next few questions are for Ms. Simard. You mentioned that the organization is mainly based on complaints that you receive. Does the OCCE have the ability to offer witnesses confidentiality for complainants or potential complainants, for example, through an informant or human source program?
No.
Do you think this would be valuable?
C'est certainement quelque chose qu'on peut regarder.
That's certainly something that we might be looking at, but right now it's not possible. It's not part of the protections that we have. I will turn to my colleagues. No. I have nothing else to add.
Does the OCCE have language capabilities to receive complaints in multiple languages?
Alors, je dirais qu'à l'interne, on a du personnel qui parle.
I would say that internally we have employees who speak third languages, but we also have access to discretionary funding through which I can have access to resources to hire consultants if need be. In the past, I think during the last year, I had connections with my colleagues at the RCMP and at CISES to find out whether they might support me if need be, and the answer was positive.
And I referred to this earlier in my testimony today with respect to at least one complaint that I spoke to where the base material was in Chinese. We had access to professional translators who are, fully qualified to do that kind of work. And my sense is that whenever that happens, whether it's Chinese, Russian, or anything else, access to those professional translators would also be secured.
Ms. Simar, you mentioned a web form on the website where complainants can lodge complaints. Is that web form available in other languages as well?
C'est disponible en français et en anglais présentement.
It's available in English and French right now.
Do you think it would be valuable to have it also be available in Chinese, Russian, the Uyghur language, etc.?
Je vous dirais que je prends note de la suggestion.
I take note of your suggestion.
Would you agree that the OCCE's limited ability to offer confidentiality and the web form perhaps in other languages might prevent some complainants from coming forward or participating fully in the office's investigations or reviews?
Je vous dirais que c'est certainement une considération, mais
I would say that it's probably, certainly a consideration, but the protection in terms of confidentiality is precisely to protect people, to make sure that what they communicate to us would be confidential, so for complainants and for witnesses as well. So it's certainly a consideration.
Add that if a would-be complainant didn't speak either French or English, they could find a way through the website to write in their own language something, and I assume that people at the reception part of the organization would have it translated such that they could then establish contact with that person.
Do you know if that has ever happened before?
Not to my knowledge.
My next question is also for Ms. Simard, but of course anyone can feel free to jump in. You mentioned it's been a practice developed by your office to inform complainants of the outcome of the work or if you close the file. Do you also provide the complainants with reasons?
En fait,
in fact, I should turn to Ms. Gigou for that.
It depends on the circumstances. So it depends on the circumstances. It depends on the material that was submitted as part of the complaint as well. But we try to be as transparent as possible, but while also maintaining the confidentiality of the details of the work as well, so that we are protecting, for example, the process, the investigative process as well. So it's determined, the content of the response or the information that's shared based on the specific fact scenario.
All right, thank you. Ms. Simard and/or anyone else, you mentioned that the office looks at whether provisions apply on a case-by-case basis. Does the office also look to patterns in the behavior of a particular authoritarian state?
Si je peux me permettre, c'est une excellente question.
That's an excellent question. All questions are excellent, but this one allows us to emphasize the work that we can do more broadly, as opposed to on an isolated case. So I will refer to the review which is underway, the possibility to learn lessons from the work carried out on the ground, for example, within some communities, with some practices. So for me, it's a continuous learning process, and that helps to identify patterns, patrons, as we say in French, to see whether we can make connections between some cases that have been closed and some that are ongoing. I will turn to Ms. Gigou to find out if she'd like to add something.
When I was there, and I assume that this is continued, the investigators would meet on a regular basis, and there would be information exchanges between them. And one of the purposes of such exchanges is precisely what you had in mind in terms of, do we see a pattern here? Do we see things that on their face, if you look at them in isolated, they look totally individual, independent, but when you put them together, and so my sense, and Mylène, you may ask, but my understanding is this is what investigators were doing, and one of the purposes was exactly to achieve the goal that you alluded to.
Okay, thank you.
And in fact, if I can maybe build on that, sorry, I said I didn't have anything to add. In particular, when we're dealing with complex files, we examine the lessons learned as well as part of that exercise so that we can build on that knowledge set and that experience and share it with others within the organization as well.
Thank you. My next question, I'll just direct this again to all of you actually, and it's about the provision of the act that prohibits undue influence.
you explained, Mr. Cote, that a foreigner can say, you should vote for such and such a person, and that would be fine. But if they say you should vote for such and such a person, or else there will be consequences for your family, that would be a violation of the act. So my question.
Sorry, that's not what I said.
Oh, okay. What did you say?
What I said is that if there was an implied threat, then you would have to look at another provision of the Act, which talks about intimidation and duress or compulsion. I forget what the word is in English. So you would have to look at that. So intimidation or duress, you would have to look at whether the manner in which the message was expressed and the effect that it may have on the people that were in receipt of that message would amount to something like intimidation or duress. So that, I hope that's what I said, but that's certainly what I want to say now.
Okay, thank you. It's interesting you said the word implicit threat because you're anticipating my question.
No, I was not.
It will be the last one.
The last one, okay. We heard yesterday from multiple community members that they are all too aware that if they don't comply with the wishes of their respective authoritarian regimes, their family members may bear the brunt of this. So my question is, when the office is looking at a foreigner with links to the CCP under either the undue influence provision or the harassment or intimidation, does the office consider that the threat is implicit if the foreigner, for example, says simply you should vote for such and such a person, but the person has family back in China or Russia or wherever?
The question you pose is a very, very complex question. You have to look at the Act and look at we would be in that case in a criminal context. So the evidence that you would have to bring forward in order to obtain a conviction would be beyond a reasonable doubt. So we'll have to look very carefully at 282.8 to determine, as I said in my previous answer, whether the threshold bringing the individual over the line, if you will, has been met, keeping in mind that when you look at 282.8a, it talks about compelling a person to vote or refrain from voting. And one of the things that you have to consider is, of course, that in Canada, 99.9% of the cases, vote is secret. The only exception is special ballot, where somebody can check and see whether I crossed the right candidate, if you will, or voted for the right candidate. So that is a very important part of this, because nobody can be forced to say for whom they voted. And of course, when they vote in secret. So that's another dimension to the problem, which to me is a very, very complex problem.
Thank you.
Thank you. Alliance démocratique.
Democratic Alliance.
Bonsoir.
Bonsoir.
Good evening. Guillaume Sirois, counsel for RCDA. I will ask my questions in both official languages. Please feel free to address the question in the language of your choice. This morning we heard about a complaint which was made in relation to a disinformation campaign in relation to a political party leader during the 2021 election. Have you heard of this complaint which was made to your office? Answer: unfortunately, I was not able to listen to the proceedings this morning, but I think that I know which file you're referring to. But if you could quote a number, we could make sure that we are referring to the same file. DIT 25, paragraph 78, page 15. It's written in English.
Ça dit, with respect to GAC, the OCCE.
We don't have the document.
Sorry, I just want to see the document to make sure we're talking about the same issue.
Can you repeat the document number, please?
Yes, it's WIT 25, page 15.
Oh, the witness. Okay, sorry, I thought you were putting it on.
No, it's a witness summary.
It will appear on the screen. Okay, it's there.
Yeah, and you mentioned complaint that was received at least, well, in fact, 2 complaints that were received concerning a disinformation campaign supposedly originating from Russia. I'm wondering similar. I have similar questions that were asked previously about what were these complaints received, and when were they closed, and what steps were taken in response.
I can certainly take some of the first part of the answer, perhaps. Again, going from memory without having a specific file in front of me. I believe our office received 1 complaint from one individual that indicated having seen a pop-up ad or something of the like. Believe there was maybe a URL that was perhaps associated to Russia. The person did not capture the pop-up ad, did not have a screen capture or anything of the like. Sometime later, we received a second complaint, but in fact, in this instance, I believe the complainant was very quick to grab a screenshot of the material, and it's based on what we saw as the screenshot, we were able to associate it to perhaps being the same thing as what another individual had reported to our office. We invested some resources into the file in terms of our analytics team to try to recreate or refine the information, and proved to be extremely difficult for us to do so. We were unable to do that. But at one point in time, I believe I recommended to the Commissioner Cote that he authorize disclosure to GAC RRM to determine whether they may have any information that could assist.
Do you have any idea of the time frame since the receiving of the complaint and referral to GAC?
I don't have the specific dates in front of me, I don't think.
It's not a problem. Maybe we can receive this information later. Can I have an undertaking or confirmation that some best effort will be taken?
I'm just looking for the information here, if I have it in the my witness statement.
You don't have the information?
I don't think I do, sorry.
Okay. If the information is easily obtainable, then
Thank you.
You will provide us with.
And it's, just to be clear, it's the initial date of each of the reception of each of the 2 complaints and the date at which we communicated with GAC RRM?
Exactly.
Okay.
Si je peux me permettre, Madame le Commissaire,
If you will allow me, Madam Commissioner, the deadline for submitting our information.
Possible, but that being said, it's really what you can get.
Parfait, merci beaucoup.
Okay, moving on to more broad issues, maybe. Comme vous savez, les algorithmes.
As you know, the algorithms of social networks present information that the user can see in a certain way. So they try to satisfy the needs of the user, their tastes, their preferences. In the area of politics, we've heard from witnesses yesterday from the Russian diaspora that may lead progressively to more and more extremism with regard to certain political positions. Within that context, is it reasonable to assume that people who are exposed to that information would not complain about the information that they're exposed to? Answer. I could not answer that. What I can say is that with regard to the situation you're describing specifically, we had 2 instances of complaints that were brought forth. Question. I could formulate my question differently. Is it possible that that problem of foreign interference be underreported to the office? Answer. Excuse me. Yes, it's a possibility, but once again, we have taken all possible measures to date to communicate a clear message. That is, if you have information, contact our office. And that message has been repeated at every opportunity that we've had. Question. Okay. I would like to bring forth now GKW07 on page 36. Page 36, paragraph 56. Here we're talking about foreign interference on the part of Russia. I will read it in English because it's written in English.
La deuxième phrase, Russia
The second sentence.
activity, including cyber espionage and foreign interference. Troisième point, on nomme un exemple, identification of divisive events and trends in rival states to conduct influence campaigns and undermine liberal democracy's norms and values. On comprend que ce genre de campagne d'influence se passe beaucoup sur les réseaux sociaux.
You can understand this type of campaign to have influence on social networks, and that affects especially members of the diaspora who are maybe more linked to their country of origin with regard to media relations. My question is, in a context where the office does not have the means to supervise social networks, or even less those of private networks like WeChat and certain Facebook groups that you need permission to access, is it easy to identify that type of activity and influence on the part of a foreign regime, such as Russia? Answer. I will bring you back to the mandate of the Act. That is, you said it, we don't carry out surveillance. That is not part of our mandate. It's a mandate of observation and application of the law, enforcement of the Act, and it's within those confines that we approach things.
And I think there are one
Madame Gigoux, and I think that
and with different mandates in this sphere as well.
And to whom can I ask the same question? Like, who's doing that kind of work?
No, I'm just saying we have our role as the Commissioner Simard has explained is one essentially slice of the pie, but there are a lot of other organizations in terms of national security and cyber that operate in this sphere as well.
So it would be more of a question for CSIS or CSC.
Well, that is going to be for you to find out.
Yeah, I guess so. Well, merci beaucoup.
Merci.
Question. I see. Well, thank you very much.
No questions here.
No question? Government?
Thank you, Madam Commissioner. No questions.
Maître Boucher?
Bon, avant d'être obligé de dire bonne nuit.
Well, before we have to say good evening, good night, we'll try to proceed rapidly. In order to avoid all speculation in tomorrow's newspapers, you talked about a file, and I will address my question to Madame Gigoux. You talked about a file that was referred by Elections Canada, and which had been closed thereafter, and it's the questions arose following Mr. Duperreault this morning, who talked about a file of Elections Canada that was referred to you that had nothing to do with foreign interference. Can you say why? What was the nature of that file that was referred, and why it was closed? Answer.
Referral or file in front of me. Based on my recollection, this was a campaign report that was not filed with Elections Canada within the prescribed timeline. As I recall, there was an extension provided, a formal extension, and the report was ultimately filed 99 days late, and it was closed with a caution letter. Again, I'm going from memory, but that's what I recall.
Merci. Maintenant, aux questions de...
Thank you. Question. Now a question for my colleague who represented Mr. Chong. He made a series of allegations, and I will direct that to the panel for those who, the person who will be judged the most appropriate to answer. In terms of, there was a series of questions as regarding the time taken by your commission, even if more powers were granted with regard to foreign interference. By the time you arrived at the end of the investigation, the elections would be concluded. There's another aspect to your work that has not been explored much during the investigations or the hearing, that is to bring things back into compliance as quickly as possible. And if possible, if there is this other aspect, do you have an example? I don't want to direct you exactly, an example of a radio that would be appropriate here. Answer. I will start to answer, and then I will turn to my colleague, says Madame Simard, to provide a follow-up. And indeed, well, I would start off by saying that compliance is what we're looking for, and in terms of elections, it doesn't directly answer your question, Maître Boucher, but we have examples where, well, there are rapid actions taken to act quickly during the election period. Once again, I will turn to my colleagues to answer more precisely. They've experienced that during elections. And I would add that it is important, once again, it's a message that needs to be clear, the one where, although we are seeking compliance very quickly, especially during an electoral period, a major part of the work at the office is done afterwards. And compliance, or the penalty or the punishment that comes afterwards, is also very important to transmit strong messages. So I will conclude there for the moment.
As an example, when it comes to broadcasting, it can be very, these are complex issues, but I can recall, for example, a scenario where it was unclear whether the advertising that was being broadcasted was in fact originating from the US or Canada, but with once that became known to our office, contact was made with a campaign to communicate our concern, and very quickly the advertising would have been pulled in those instances. Ultimately, I think we determined that the initial contractual arrangement for the advertising had actually been made with a Canadian company, and in fact they were reimbursed for part of the advertising that was canceled, again from a Canadian company. But nonetheless, even though we didn't have all the information, we took active steps very quickly to try to resolve the situation. Again, I don't have this specific file in front of me, but to the best of my recollection, I believe that's one of the scenarios.
Commissioner, I'm very sorry to interrupt. It's Erin Dan speaking. Our interpreters are unable to work past 7 o'clock, so I just wanted to alert everyone.
On va s'en tenir à bonne soirée. Just pour
a question, we'll wish them a good evening. Very quickly, a last question on the infamous luncheon that Mr. Van der Weijs had. Despite all the rumors or articles in the newspapers, is it correct to affirm that your investigators met witnesses and also Mr. Van der Weijs, and it was clearly established that that entire luncheon was done following his request? Answer, yes. That's everything? Thank you.
Everyone, it's going to be a long weekend. So,
For most people.
happy Easter to everyone. Merci beaucoup. Alors, bon.
Thank you very much, and have a good weekend.
Commission has adjourned until tomorrow, has adjourned until next week. Cette séance de la Commission de l'ingérence étrangère est levée. Merci.